or pleasure. Shall we welcome them with a large round of applause? A warm welcome to each and all of us here. And this is a momentous occasion, the Symposium on Interface of Emerging Technologies, Intellectual Property Rights and Policy. So on this momentous occasion, we are surrounded by a huge lot of experts, practitioners, and what more. So it's my earnest attempt to welcome, with profound gratitude, we welcome you, sir, Justice Dr. Vineet Kothari, Chief Guest, the Acting Chief Justice, former Acting Chief Justice, Gujarat High Court, and Dr. Ramni. Thank you so much, ma'am. And let me invite each one of the practitioners, the experts, the academicians, and the representatives from the bar and the bench, and the researchers specifically in the field, and not the least, my beloved students over here to attend this particular program. Thank you so much for your time, energy, enthusiasm, and zeal. And this is going to be a great opportunity from the part of Manipal Law School, MAHE Bengaluru campus. And students might be knowing me. For those who don't know me, I'm Dr. Anuja, Associate Professor from Manipal Law School. It's our pleasure, sir. We acknowledge your presence, all the guests and all the faculty, your presence over here, and the painstaking efforts that you have taken to be here. This is a program, a symposium specifically organized and designed to commemorate the National Technology Day falling on 11th May of 2024. So as we all know, there has been a huge paradigm shift from the agrarian economy to the industrial economy and then to the knowledge economy. And when it comes to the knowledge economy, innovations are the lifelines. As we look to international mandate, the UN General Assembly resolution of March 21, 2024 talks about how optimally we can safely, securely, and trustworthily use or AI specifically in the IP sector. As we move to the national context, we see India's purge, the spiraling efforts with regard to coming up with the 5 trillion economy in the IP-intensive sector. And as we move on to the individual lives wherein AI is affected, we always are entangled with the social, economic, and the ethical challenges. So we thought this is an earnest attempt from Manipal Law School, this particular program, symposium, emanating from the IPR cell of the Manipal Law School and fully headed by and led by Professor Dr. Avinash Dadij, who guides us throughout, and specifically designed by Dr. Indraneel Saha, Associate Professor and Chairperson of the IPR cell. And it is my honor to invite you all, welcome you all to this wonderful occasion. Thank you so much for being together here to learn from each other and grow together. So with no delay, may I request the chief guest and our invited speaker, accompanied by Professor Avinash Dadij and Dr. Indraneel Saha, to do the honors. First, we will start with the floral tribute to our founder, Manipal Group, Dr. TMA Pai. And then we'll have the lighting the lamp ceremony. Thank you so much. There is no darkness so difficult and so dense to purge that it cannot overcome the light. And it is all about the abundance of brightness and prosperity that we are here learning from each other and growing together. So now, may I request Professor Avinash and Dr. Indranil Saha to accompany Professor Dr. Avinash to felicitate our guests. May I request our chief guest to please accept the honors, sir. It's our pleasure, it's our honor that you are here, and we are here for a committed mission from Manipal Law School together. Thank you so much, sir. May I request Dr. Ramani to come forward? Ma'am, we are so delighted to have you here. Ananya. Thank you, ma'am. Thank you, sir. This symposium, Emerging Technologies on Interface of Intellectual Property Rights and Policy, was a brainchild of Dr. Indranil Saha. To talk about him, Saha is a committed teacher, a very highly committed researcher, come academician as well. He took his PhD from Indian Institute of Science, Bengaluru, specifically focused on physics and highly passionate towards the interface of law and technology. I request Dr. Saha to introduce the theme to our audience.
A warm welcome to everyone today on the National Technology Day, as you know, and thank you, Dr. Anuja, for the introductory speech. So, as you know, all of us have gathered here today to not only talk about intellectual property, but to talk about interface between technology and law. And this technology that today we are primarily going to focus in this symposium as of today is how artificial intelligence is penetrating into our lives and changing various aspects of our lives. Because if you look at our life is a combination of various technologies as well as the social aspects associated with the technologies that we are using. Okay, so one must understand that the kind of technology that you're using also has a scientific impact, a legal impact, as well as a social impact. So how this technology is penetrating into our everyday lives through pharma, through biotech, through the kinds of gadgets that we are using, through the, being regulated by the laws of the country, by the intellectual property laws of our country, as well as some international laws, okay, which are governing such technologies, because technology is not limited, in general is not limited to any geographical location. It is spreading worldwide. So we need to know what kind of laws are governing such technologies which are widespread around the world, like internet technology. Okay, so as of now, India, as we all know, does not have any legislation for artificial intelligence. Recently, there has been a legislation coming up in the European Union, which is called the EU AI Act, and there is a lot of deliberation going on that. India, last year in September, enacted the Digital Protection Data Privacy Act, and we are facing a lot of roundtable discussions all over India as to how this DPDP Act, in short, if I may call it, is going to get implemented. How is it in comparison to the GDPR of Europe, which is the General Data Protection Regulation, which is called the mother of all data protection regulations, basically. So if you're a data protection analyst, if you do not know GDPR, people do not consider you to be a data protection analyst at all. Okay, so what we thought was that on this National Technology Day, we would try and focus on something very contemporary, which is changing our lives very rapidly. And naturally, the first choice which came into my mind as the convener was AI, because if you look at AI technology, personally, I would say that AI is nothing new, actually. You see, when the space shuttles were sent, they were working on AI. Okay, when Gary Kasparov beat okay, a machine, a supercomputer he was playing, I think in 1997, that supercomputer was running on AI. The missiles that are launched, they are run on AI. The flights, especially even the commercial flights as well as the jet fighters, they were running on AI. But now what has happened was that this technology was primarily a defense technology, if I'm talking much earlier, but now this technology has come down at the commercial level. Okay, so many of the technologies which you may find commercially now were being used by defense and research organizations 50, 60 years back. I do not know how many of you know that the internet that today we are using was actually not invented by any software company. It was invented at CERN, Geneva. And as you know, CERN comes into news every now and then because of its Large Hadron Collider, where they are trying to imitate the conditions that were present during the formation of the universe. Okay, so by they have these very huge storage rings, and they have rings as well as pipeline, which is having ultra high vacuum, not just vacuum. There are levels of vacuum, which has ultra high vacuum, because if you do not have ultra high vacuum, the molecule or the particle that you are accelerating will ionize, and you would not have anything. So what they're trying to do in CERN is that they're trying to take two such, say, hydrogen ions or two hydrogen atoms, and they are trying to accelerate them at very high voltages, like 25,000, 30,000 volt, and so that when they collide, the atom breaks, and you get at the quark level. As you know, for many of the students, the atom can be broken down. Okay, the molecule can be broken down into atoms. Atoms can be broken down into proton, neutron, and electrons. Electrons cannot be broken down as of now. It's a fundamental particle. Nobody has been able to do it. But the proton and neutrons can still be further broken down into what is known as quarks. And when universe was formed, okay, if we believe the Big Bang theory, initially there were only photons and quarks. And the temperature of the universe was like billions of degrees, and universe expanded. So nobody knows what happened in the first 10, 20 minutes of the universe, how it was expanding. That physics is unknown. That part is called Planck era. So whatever physics we have till now is after like 10, 20, 30 minutes. Nobody knows. So at CERN, they are trying to imitate that condition, what happened during the formation of the universe. And they have been doing this research for pretty long, and it is there where the scientists thought we should have a technology instead of the telephone, where we could communicate with each other sitting on the desk. And this is how internet was actually discovered. And after discovery of the internet, it was a closed door technology only used by CERN. They thought this is not going to be very useful, so they left it, and that is where IBM and the other companies took it up. So that is how you have internet. Okay, so many of these technologies of AI which you are using nowadays in your mobile phone and everything, they were already available with research institutes, especially defense institutes, long back. So AI is nothing new. But the way AI changes your world the moment it comes into commercial use is a different issue altogether. Okay, me doing some virus research in a laboratory is different than doing a virus research in my lab and making something and selling in the market. There are a lot of things changes. The society comes, the laws regulating it comes, and so forth. Okay. So whenever technology comes into picture, obviously intellectual property rights comes into picture. And as we know, intellectual property rights is not just one right. It is like a broomstick. It is composed of a bunch of number of rights, like for scientific inventions, protection of scientific inventions, you have patents. For protection of literary, artistic, dramatic work, musical work, artistic work, sound recordings, you have copyright. Okay, for protection of your brand business, you have trademark. Okay, for protection of semiconductors, layout design, you have the Semiconductor Layout Circuit Design Act. For the geographical indication protections, you have the GI Act, and so on and so forth. So it is a bunch of rights, which together is called IPR rights. Today we will primarily focus on AI and the IPR rights, like patent rights, which are coming, copyright, because if you are using AI in music, copyright comes into picture. Okay, so certain kinds of things, or the designs, because designs is in India is governed by the Designs Act. And I would like to inform all of you that many of the times, in recent times, I have seen over the internet that people have been claiming that we have a design patent in India. Okay, so I personally, this is my personal opinion. In India, you cannot have a design patent. In India, you have a Designs Act 2000, America, if it is USA, yes, there are 3 kinds of patents which are available. One may look it up at the USPTO. You have design patents, you have plant patents, and you have utility patents. But in India, there is no such provision of a design patent. Okay, so it's a misnomer. Please do not be fooled by the fact that you have a design patent. Okay, if you have a design, you want to register the IPR, please file under Designs Act 2000. If it's a scientific invention, please file patents under Patents Act 1970. So today, what we thought was that since AI is now penetrating into our lives in every sphere, let us have a panel discussion of very top level people in the field, not only in law, but in the industry. And this industry should spread in domain from pharma, to automobile, to engineering, so that we can understand in which domains, how much penetration of AI is happening and to what extent should it happen. Should we give a lot of leverage to AI and sit back and just depend on the computer programming which is running the AI, or should the final control rest on the human beings at certain decision-making points? Otherwise, the question of liability comes as to who will be liable, the machine or the human being. For example, if a medical surgeon is doing operation using the Da Vinci robot, the surgeon is sitting in Mumbai, the patient is in Apollo, for example, say, or any other hospital, which is in Delhi, and the robot is functioning under the instructions of the medical supervisor, and if the robot does something wrong, then at the end, whom are we supposed to blame legally? Is it the robot, the programmer of the robot, the company which is manufacturing the robot who sold it to the medical fraternity, or is it the doctor who does not know the programming of the robot but knows how to control the robot? Or is it the actually patient who has signed a disclaimer form knowing that he or she will be operated by a robot? It's a very difficult question to answer. Everybody has their own perspective. So we have picked up 3 prime areas actually today for discussions by eminent panelists from India. And in the course of the program, Dr. Anuja will be introducing the panelists individually, so I will not do that now. So the 3 prime core areas are biotech and pharma, where AI has penetrated, and we will, through the panel discussions, try to elucidate how much of penetration is necessary, what can be allowed, what should not be allowed, and even if there is an allowable penetration, if something goes wrong, who is to be blamed, how that can be rectified. This is the most important part. Liability part is the part where law creeps in, actually, because everybody likes using technology, but when something goes wrong, then whom are you to blame and who will take the blame? That's a very important aspect which has to be legally decided. The second area is, of course, since we are talking about law and regulations, so the regulations at present in India, be it in IPR, be it in the corporate sector, be it in the other regulatory aspects, does anything need to be changed in the light of the growing penetration of AI? If you look at AI technology and somebody is doing research on AI, the problem with the researcher fellow nowadays is to figure out his research problem in PhD. Because once he starts his PhD on a certain topic in first year, by 5th year, that technology is nearly now obsolete. So his PhD is undergoing a very massive challenge as to what he should do. Because in first year, this fellow also does not know how the AI will change in 5th year. So it's a very difficult thing to assess that the laws that we are making today, that law will hold good for the AI we are going to have in 5 years. So projectability of the AI penetration in coming 5 years, 10 years in different fields is an important aspect that needs to be ascertained by law-making authorities, to my earnest belief. So this is the second panel discussions that we're going to have, and especially since India has a booming startup market, and a lot of young people are pulled into the startup market, which is a fantastic thing for any country, because unless you are having inventions and innovations on a diversified field, you cannot have progress. But then startups are also facing problems in your technology transfer, because that technology has to reach from your lab or from your office, where you have this small office or small setup, to the industry where it can reach the people. But there are hurdles in it, both technical hurdles as well as regulatory hurdles. So how AI can improve on that? This is one aspect that we can dwell upon. Or is AI a challenge to that? Are the startups facing challenges because of this growing AI and they're not being able to put up with it? This may also be a major challenge. So that portion will also be taken up by the second panel. The third panel that we have, they will delve on how the IPR systems benefits inventions and innovations in the era of AI. And I would like to tell all the youngsters here, invention and innovations are not the same thing. Invention is a legal word which has a definite meaning under the Patent Act in India as well as Patent Act in any other country. Whereas innovation actually may not be an invention. Okay, so there is criteria for invention if one reads the Patent Act, and whereas innovation, you can mix 2-3 inventions and actually create an innovation. So if you look at Thomas Alva Edison, he is called both an inventor as well as innovator. He has huge number of patents, but then he has also created things which he does not have a patent for, where he has used things created by other people with their permission, and he has created something fantastic. Okay, so an innovator is a person who may be a scientist, may not be a scientist, may be a MBA, may be a doctor. There is no criteria for becoming an innovator. Okay, please do not think that today you are a student of social science so you cannot invent. It is a wrong concept. You need to have an idea which will work in the market. You have to think like a consumer. I tell everybody whenever I'm addressing that if you want to invent something, the best way to think is you are a consumer. Go to your kitchen, start from your kitchen. Go to your kitchen, pick up an appliance and see what new modifications you would have liked in this appliance which is not there, which would have made your life easy. That becomes your inventive step. Work on that. This is how, the inventions keep on coming in the market. Even if something is there, you can modify it to such an extent that you, create an inventive step, and you can have patents. And we will also discuss whether at all IPR protection is required for, technology transfer and proliferation of your business. If I'm a startup, can I not have IPR protection and still be flourishing? Will big companies buy my invention, what I call invention? So this is something that the third panel will delve upon. So these are the 3 main aspects that today's conference will focus on. And I really hope that the esteemed panelists that we have in India, they are not only esteemed panelists in Bangalore, they are well known in India as well as the world. So be grateful and lucky that today at Manipal Law School, you are being able to witness such stalwart people sharing their esteemed knowledge of more than 15-20 years in both law and science and helping you to shape up your career. With that, I'll end my thought for today. Over to Dr. Anuja. Thank you.
Thank you so much, Dr. Indranil Saha. So I need not express by my words as to how passionate Dr. Indranil Saha is about the topic. Thank you so much, Saha, for the passion you bring it towards the program. Now I request Professor Avinash Dadich, Director, Manipal Law School, to address the gathering. Sir comes up with a vision always. He makes sure that it is a passionate vision, very clear and dear and near to him, and he relentlessly works towards its completion. And he articulates in such a way that you will be spellbound with regard to how you will be conducting and organizing such programs wherein interface of law and technology comes in. So sir is highly a passionate leader, specifically in the field of technology and law, and Manipal Law School is committed towards the vision of coming up as a tech-focused law school, evolving as a global legal educator. Please, sir, we invite you.
Respected Justice Kothari, Dr. Vimani, my dear colleague Dr. Saha, Dr. Anuja, other faculty members, and invited guests and speakers, and then finally my students. It's a Saturday, so we are all giving our extra efforts. Some people are giving efforts to share their knowledge, and some students, they are giving efforts to receive the knowledge. I think that's the purpose of the university. University is nothing but a platform where ideas can be exchanged, debate can take place, especially the controversial ideas can also take place in the university system, because maybe in corporate or in judicial or in government, some ideas may be immature to discuss or maybe not politically correct to discuss. But in university system, I believe that as a professor of law and student of law, that this is the time that we should discuss some serious ideas. About the technology, I think we are excited. At the same time, we are very much concerned. So there are clear groups, One group is, oh, this AI is going to destroy, the AI is going to take control. The other is saying, no, AI is going to make our life very easy. It's just like a technology, just like other technologies. So this debate is there, and it's not a new debate. I was reading very funny, I think before, a few days back. In late 19th century, when the railroad was introduced in USA, some people have a very serious concern that rails are running so fast that women's lungs will not be able to take it, and they may die. So these type of stupid concerns were there. And when the car was introduced in UK in late again 18th and 19th century, the people were highly concerned. They used to believe that some evil forces are running these cars. Okay, it's not possible. So religious people, especially from particular area, they were very much concerned that I think we need to regulate it very seriously. So they made a very interesting act in UK, Red Flag Act. And the act was like this, that you cannot run your car more than 2 miles per hour. So 2 miles per hour means 3 kilometers per hour. But still it's dangerous, because one devil is sitting inside, inside the car, and the devil is taking the car ahead. So there has to be one person ahead of the car with red flag and shouting that devil is coming, car is coming, so that people can, save their life. So historically, I think people have a lot of strong concerns, and because of that, car industry could not develop in UK, it finally developed in Germany. And so my argument is very simple, that technologies are very weird when we see them in the first stage. But slowly and slowly, the beauty of human civilization that we adapt, and we adapt very fast. I think that's the only beauty of humans. Otherwise, you will not find any beautiful part in the humans, because since 10,000 years, we are only fighting, we are killing each other, we are destroying environment, and we are doing all bad things to everyone. Whether it's animal, environment, humans, I think this is one of the most strange creature on the earth, where they are not satisfied with anything. If you put rationality, then human race should ended very much, maybe 2,000 years back. Because they are constantly fighting. You don't find these type of animals, like lions are not fighting in Africa, and animals are not fighting like this. They are fighting for something, then they stop. But there is no end of the war and conflicts and greed. However, we are surviving just because of the one virtue, and that virtue is that adaptability, that we adapt very fast. We resist, we understand, then we adapt, and then we move on. I think that's the beauty. But then the larger question with one camp of AI which they are raising, they are asking very fundamental question. Is it like the same before? We had a lot of technology like the computers, railroad, IT. We had a lot of technologies, we adapted. Can we apply the same reasoning for AI? This is like a larger question. Nobody knows the answer. This is like a very open-ended question. Some people, they say, yeah, we will adapt, don't worry. We have seen so many crazy things, and we will see this also. Don't worry about it. Other camp says, no, it's problematic, because, this time you are creating something which can challenge your intellect. So far, whatever you have developed, you controlled. Like the railroad, IT, if IT is not working, you can plug, you can shut it down. If rail is not going well, you can stop it. You had control, the red button. And the red button was controlled by the state, by the government. If something is not working, government can immediately come and say, okay, stop it. Even some companies are very keen to advance their technology, like especially human clones. I think a lot of companies are very keen to develop human clones. But then the national and international level, we agreed ki no, yeah, this is quite danger, red button, stop. So this is how in last 60, 70 years, the state, national as well as international organizations, they have used the power of red button. Please stop. You cannot develop it more, or you can develop but with lot of rules, regulations and supervision. So governments had the control. And we believed in our government somehow because we believe they are democratic, we have elected them, they are the voice of the people, and there are a lot of check and balance within the state, like the judiciary. If government is not doing, judiciary can intervene. So we believed in this liberal system where check and balance can be created by the state. However, what's new in AI, guys, especially the young people, you should know, AI is not governed and developed by governments. I am very sure that no government in India or at the international level have clear idea that how AI is being developed and how AI is functioning. Even the Google CEOs in the picture, he admitted that sometimes even we don't know how this AI is being developed. We put some algorithms for some one reason, and with that reason also the AI gives another reason also. So that's like the dark side of the AI, which even we don't know how it's working. And that's the beauty of the AI, because if you remove that dark side, that mysterious part, then it will not work effectively. You see? So we want to give more autonomy to AI to develop better AI. So that mysterious part, which is not known to even IT companies and tech companies, I am very sure that government has no idea that what is happening in AI. Though they are trying to regulate it, especially EU AI Act, they try to started, regulating the AI. But again, the behavior of the AI. So it's very interesting time for young lawyers, because AI is moving out everywhere. It's going to affect every area of the society, every part of your human civilization. And then as a lawyer and judges, like you will be lawyer and judges, corporate lawyer after a few years, it will be a challenge for you, because you have seen only the positive side of technologies last 20 years. And you are very much comfortable with technology, but then the new challenges will come in democratic setup about the human right violations, transparency, data privacy. Interestingly, I think 2 days back, the French Competition Authority imposed penalty on Meta for data privacy violation through AI. Interesting, they imposed penalty. So this is the first penalty imposed by a major developed country by using of AI in data privacy. So this is going to be very, very challenging time for young lawyers, because when you will move out from this college after 3 years, 4 years, in your companies, in your law firms, the bigger question would be that how we are going to help corporates to develop and implement AI, because a lot of resistance is going to happen from the government side. Very soon we will have Indian AI Act, we will have Data Privacy Act, Digital India Act, Digital Competition Act, and more digital types of laws. So this is a big challenge for young lawyers, how to understand these areas right now. I know it's very complicated, and trust me, in this room, if anyone claims that I understand AI fully, then I think that guy might be a god or liar. Because nobody understands AI, how things are happening. Especially in Indian market, where we are not developing AI. The core technology is not developed in Indian market. We are just trying to mimic or maybe copy paste or develop something. So this is a very interesting aspect and time in India where we understand that how AI can be beneficial for our society and for our companies. At the same time, people sitting in the front row, you are the leader in corporates. You know how corporate works, The ultimate objective of corporate is profit, and then some social regulations. But I think it's your moral duty that you understand that how this AI technology is being used and developed in India, how it's going to create positive and negative aspects in Indian market. And then I believe it's your ethical and moral duty to inform your board and your top leadership, especially CEOs and CFOs and CTOs, that I think we need to have a relook on AI technology, because in long term, it's not good for anyone. In short term, maybe we will make some quick money, but in short term, good, but in mid-term and long term, it's going to impact the society, and consequently, it's going to impact our company also. I know it's difficult in corporate world because CFOs and CEOs, they don't want to see the long term. They want to see maybe the next quarter or maybe next to next quarter. But I think this is our role as a lawyer. We are always the people in corporate, in boardroom. We have huge responsibility to tell them, sorry, this is not legal. Or maybe this is legal, but this is not ethical. This is not moral. And they might ask you, okay, how does make an impact if it is moral or unethical? Then you should remind them ESG, that now ESG is also there. And finally, you should tell them corporate social responsibility, that you have some social responsibility. Maybe this action is not illegal today, but it's immoral and ethical today, not illegal. But in future, it might be legal. It might create reputational damage to your company. I know it's a tough task. You may lose your job. They won't like you. But I think that's our job as a lawyer. But it's a difficult job. Just like a doctor, just to cut someone's body is not an easy thing. But that's a doctor's job. In the same way, I request my young students, please read about this AI technology, ethics, rules, regulations, democracy. It's heavy stuff, I know. Maybe you won't understand everything right now. And trust me, when I was doing my LLM in France, my professor Arnaud Renoir, whatever he told me in the classroom, I could not understand more than 20%. That's a fact. I could not understand more than 20% whatever he was talking. But later on, when I moved in my life, in my practical life, then I realized, then I understood his concepts. What he was saying in that classroom, after a few years when I was in the real world, then I realized, I think that's the meaning of his statement. So a lot of things you will not understand today, but it will go to your subconscious mind. Okay? And when time comes, when you will encounter that situation in your life, that subconscious knowledge will help you. Okay? So please don't feel bad if you don't understand something today or if you understand less. It's fine, because your subconscious mind is taking more data than your conscious mind. So 99% data is in your subconscious mind. And that mind is listening and storing the data. So please listen. I know it's tough, especially when you don't understand, but it's going to be a very high level discussion on intellectual property. And I request all the speakers that when you talk in your panel discussion, please remember that these are first and second year students and LLM students. So you please have high level intellectual discussion, I would appreciate. But at the same time, if you can add some more information in your discussion, if you can tell students, some basic information during your panel discussion, I think they will be more engaged with you. Okay, otherwise they are here and they will start using their mobile. You know that. Okay, nobody can stop them. So I think now you are a teacher. Okay, when you come to a law school, you are a teacher. So please remember, that's my humble request. Sometimes I have seen that top class speaker, they speak very high, but then students are, what is he speaking? I have no idea. So please keep your intellectual level very high. But at the same time, if you can give some basic information, if you can explain those concepts in simple words to these students, they will more appreciate your presence. Thank you very much.
Thank you so much, sir. And it is always said, a leader is the one who knows the way, shows the way, and goes the way. Thank you so much, sir, for being with us and inspiring us throughout. Next is the speech by our invited speaker, Dr. Remini V. Marakani. She is having a presentation with her to show us and then to explain the details of the presentation. It's my pleasure and honor to introduce Dr. Remini V. Marakani to you all. She is partner Lex Orbis Bengaluru. She has 18 years of experience in patent preparation and prosecution. She was working as a senior director with Claire Wolex Knowledge Process Private Limited. She was mentoring patent engineers and supervising the patent development team in Bengaluru to ensure high quality of patent applications. Prior to this, she was a director at Intellectual Ventures. In this role, she was responsible working with inventors from prominent Indian universities in the areas of material science, polymer chemistry, and other related chemical sciences. She held the positions of an IP counsel with Philips Electronics India Limited and a lead scientist with John F. Welch Technology Center, Bengaluru. Before moving to IP and research and R&D section, she was an assistant professor at one of the engineering colleges in Bengaluru. She received her B.Tech and M.Tech in chemical engineering from Osmania University, Hyderabad. She received her PhD from Indian Institute of Science, Bengaluru. She received her JD and LLM from then Franklin Pierce Law Center, now University of New Hampshire School of Law. She will be presenting on the topic, patents and patent waivers for vaccines. Thank you so much, ma'am. And now we are going to hear the woman empowerment, the woman power on the days. Please, ma'am. He gave me this. I'll be able to manage. He gave this. I'll be able to manage.
Good morning, everyone. I really thank Dr. Indranil and Dr. Avinash for giving us an opportunity to be with the youngsters. One just request to Dr. Avinash, maybe he should have warned us before that the audience is going to be youngsters, first year students, second year law students. We could have managed our presentations in such a way that it be more interesting for you. I made a lot of slides, maybe I'll skip some, I'll spend more time on basic slides. So I should have started my presentation with basics of intellectual property. That would have been more better. Anyway, it doesn't matter. I'll try to make as interesting as possible. You can stop me anywhere now, or we can discuss. I'm available here. You can talk to me. I know none of you may be practicing patent law, but it is nothing wrong to learn something new, which may be useful for some time. Maybe you'll be a law firm, tomorrow you'll go to a corporate, and some of your clients may need some basics of intellectual property. Then you'll be able to understand the words at least. What is a copyright? What is a patent? What is a trademark? Okay, I'm a hardcore scientist and turned to a patent attorney. So I will try to minimize my technical stuff as much as possible. Okay, so I'm odd man out or odd woman out. I'm not going to speak anything on AI. I'm speaking something about IP and vaccines. I know the minute vaccine, what rings in your mind of late, you know. So I'll be touching about something about corona vaccine also. So I'm starting with my first presentation with patents. We have intellectual properties, right? We have so many intellectual properties. We have patents, copyrights, trademarks, designs, the different these things. Patent is the one. Aditi was accompanying me in the car in the morning, and she was asking me why can't any graduate practice patent law? The only intellectual property, in the intellectual property, only patent needs science background. That is the requirement. Suppose, why? She asked me, why ma'am, why not others? Suppose you are an inventor. Assume that he is an inventor and he is a chemical engineer, and he'll come and explain me what he invented. For me to understand and give his patent a protection, I need to understand the technology. See, I am a patent attorney, but I cannot handle AI-related inventions. I cannot relate computer-based inventions. I can manage chemical engineering, I can manage biology, I can manage, because that is my core technology. So for patent lawyer, it is necessary for you to be a technology person. So even to write the patent agent exam, you have to have a graduation in science or engineering. Whereas trademark attorney, you can be a lawyer. For trademark, that's fine. Whereas for patents alone, you have to be a technical person. So I will make it as general as possible for you to understand. Okay. What is a patent? So you have a problem, right? And as someone was mentioning, Dr. Avinash was mentioning that, Indranil was mentioning, right? If you are a social law person, don't think that you can't be an inventor. You are walking on the way, or you want to draw the water from the well. It was very dark, and it was very hot, for example. And you wanted, that night, you wanted both fan as well as torchlight. So it stuck to you. Oh my God, I have only a torchlight in my hand, I have fan in my hand, I can't draw the water. What if I can combine both together? So you need not be a scientist for that, right? So you can just be an inventor. So there is a problem, you want to find a solution, and as he mentioned, all inventors need not be innovators. All innovations need not be inventions which can be patented. For you to get a patent, we need 3 requirements. The first one is novelty. That means you should be the first one. No one else should have done that before in the world. For example, I'm driving on a two-wheeler and it was raining. I'm having glasses. And I was wondering whether I can have a small wiper to wipe my glasses. This was an invention, believe me. So he was driving in a two-wheeler and his glasses were wet because of the rain. So he wanted to have a wiper. So he applied for the patent application. The patent was denied because the same concept was in a comic. So it's not an invention, it was there in a comic book. So it was not novel. Novel means you should be the first one. It need not be in a newspaper article, it need not be in a movie, Star Trek. Those are all hi-fi, right? But they wouldn't have thought anything about it, it's only graphics. But because of that, some inventions can be killed. So you should be the first one to invent. That is called novelty. And the second one is inventiveness. That may be a little more subjective. So inventiveness is what? I'm a person skilled in the art. I'm a chemical engineer. I can see this one, and combine and can come to the invention. So that is inventiveness, non-obviousness. I mean, don't worry much about it. This is very subjective. So how do you, I have a knob. I'm opening a door, and it is a metal knob. And what happens if it is outside? Metal gets corroded, right? When rain falls, metal gets corroded. So I want to replace with wood. I came up with an invention. Novelty, yes, no one has done with wood. I'm the first one to do with wood. Novelty, I passed. But there is a technical paper, which says that metals get corroded and metal needs to be replaced. So examiner said, it is obvious. I combine this technical paper, I combine this one, and your invention is obvious. So that is the second one, is called non-obviousness or inventiveness. These are the second condition. You remember, Indranil was mentioning that not all innovations can be inventions. For invention to become a patent, you have to have these 3 conditions. First, novelty, second one is inventiveness, and the third one is industrial applicability. What is industrial applicability? It has to have some industry applicability. In the US, there is a lot of snow on the roads. So how do that's very fine. They are finding it very difficult to drive. So one person came with an invention that he wants to run the steam pipes and run the steam under the snow. Very good invention. But is it possible technically? How much energy is needed to generate steam to melt so much of snow? So patent office said it is not patentable. It is a novelty, it is novel, it is inventiveness, but it doesn't have industrial applicability in the sense it is not feasible to apply to the industry. So the patent was denied. So these are the 3 conditions for us to get a patent. So why should we get a patent? Why should I apply? Okay, I have an invention, I worked hard, and I want to practice. Why should I go for a patent office? Why should I go to a patent attorney and draft a patent application? Why should I take so much of trouble? Because you have worked so much, you invented this, he wants to copy that, and he also makes that. So your ready solution is available for him, and he'll copy and he'll get the advantage of all your hard work, right? You don't want that. This is your baby, this is your hard work, this is your intellect's property. So you don't want them to copy it and practice it. So you can stop them from copying your invention by filing a patent application. So you can give it to, you can practice, or you can license to others. So licensing, I think you are all lawyers, you will be drafting the licensing agreements. So you can license your patent invention to someone else, they can make and they'll pay you royalty, you will get money. They will not copy just like that. To copy or to use, they need to pay you money, they need to pay you the royalty. So that way you can get money out of your patents. And as I put a patent application in the public domain, and others will know from there, and they will start making more inventions. So technically we will be moving, society will be moving forward. Okay. So what is a patent? So we are all done. I have an application. It is novel, it is inventive, and it is industrial applicability. I went to the government patent office. I got a patent. So you have a monopoly. Government, no one can practice your invention for 20 years. So you are the monopoly. You have the rights on your invention. No one can copy, no one can sell, no one can manufacture it without your permission for 20 years. That is the monopoly government gave you for your patent application. That is the right you have. Okay? Instead, in turn, what government wants you? They want you to completely disclose. All your technology should be clearly written in a patent application. Why? Because tomorrow someone wants to practice, they should not again reinvent the wheel. Your patent application should be so clear that they can practice right away. They can start using, they can pay you money, they can start practicing it. So that is the duty of, your duty is to disclose it completely. So what all you can stop others? You can stop others from making. They cannot make your product. They cannot use your product with your permission. They cannot sell the product, and they cannot import the patent product into the country. Okay. Again, why should we file a patent application? I already mentioned. You spend a lot of money, right? Inventors, pharma industries spend lots of money, lot of resource, lots of time, lot of efforts. And if someone comes and copies, all the efforts are lost. They need to get back their money. They need to get back their investment. How do they do that? By filing a patent application and stopping others from practicing for 20 years. Okay? If invention, as I said, if everyone copies the invention, there is no motivation for me to work hard. You have to get back money on your investment. Return on investment is very important. And as I get money, more and more money, it encourages me to invent more and more. Okay. Now let's just see what are vaccines. We all know what is vaccine. Vaccine is a word coming from Latin. It is cowpox, like how we have smallpox. Those days, cows also used to get a disease. That's how the word came from Latin word. Vaccine came from the word vaccinia. How do they develop the vaccines? Basically, it's naturally. Suppose you have what is polio vaccine? Polio vaccine has polio virus. We all know, right? The diseases can be either viral diseases or bacterial diseases. So if you have a viral disease, polio, so how will they generate the vaccine? They take the virus, polio virus, put it in your body. What will happen? Your body fights against the virus and produces antibodies in your body. Right? That's how it makes nothing. Vaccine is nothing but the same disease we are introducing in your body in a small quantity, of course. Very small quantity. When you introduce the virus in your healthy body, the body starts producing antibodies. That's how the vaccine is developed. Okay. So vaccine is nothing but viruses. It's like live organisms, live microorganisms. Okay. Now, there is a question. Bacteria or virus or vaccine is nothing but live organism. Is it patentable? Is it novel, non-obvious, industrial application? All that's fine. We have something else in Indian Patent Act. One section, you must be knowing the acts, you must be reading the acts already. I don't know if you are in second year. There is Indian Patent Act. In that there is one section called Section 3. Section 3 defines what are not inventions. Maybe India is the only country which tells, besides those 3 conditions, there are some other conditions which says that these inventions are not patentable. Section 3 defines that. Okay. What are not patentable? There are many sections. I picked up only that suits to the life sciences. So Section 3C says, mere discovery of any living thing or non-living thing occurring in nature. Suppose you are walking in your garden. You took out the soil and you saw a microorganism. It looked new. Is it patentable? No. It's just occurring in the nature. You didn't do anything. You just picked up the soil and you found it. It is not patentable. Section 3C says that naturally occurring non-living organisms are not patentable. Next is Section 3D, new form, new use of a medicine. This is a big controversial topic for the developed countries and especially for pharma industry. What they do, pharma industries, they develop a drug. They get monopoly for 20 years. At the end of 18th or 17th year, they make salt out of the drug. Now they say, this is a new salt. Till now the drug is it is valid for 17 years. In the last minute, they came up with a new salt, and then now they said, we are patenting this. They get monopoly for 20 more years. So India said, no. It is a known drug. You just make it salt out of the drug, and you say it is tasting good. It is not patentable. This is called evergreening effect. What is evergreening? You keep on inventing. Just come up to the 17th year, add some more feature. Again for 20 years. Again 20 years. You keep on doing this, the pharma industry. So the developed countries are extremely unhappy. There are landmark cases in India. I don't want to go into those cases. Novartis is a big case. So this is called evergreening, and section 3D says, unless okay, I'm taking the drug for 1 month, now with the new drug, I can take only for 15 days. You show me, then I'll give you patent. That is called efficacy. If the drug has efficacy, then you can patent it. But you can't say the drug is tasting good, the drug dissolves in water well. Those kind of features you cannot patent. So that is called section 3D. And next is this 3I. India and Europe are these countries which they say method of treatment is not patentable. You can't have a method of treating a cancer patient that is not patentable in India and Europe. US is more liberal. US, we have method of treatment patents are allowable in the US. And section 3J, plants and animals are not patentable. We have a separate patent act, which is called Plants Variety Act. So you can file your new plant. Suppose you come up with a new plant, you can file under that, not as a patent. And last is traditional knowledge. I think you all know, I don't know, you maybe youngsters, you won't have heard. In the US, they have filed an application for turmeric. Turmeric has a content called curcumin. Curcumin is, it's an ingredient, main ingredient of the turmeric. In the US, they filed a patent application saying that curcumin can be used for treating the disease, wounds. Then India fought. India said, we know haldi. Grandmothers used to apply. If you have a wound, if you cut, you apply haldi, right? That is so traditional knowledge to us. So you can't patent. So, we invoke the patent. US got a patent application, some industry got a patent application for turmeric. India fought, and India said that this is a traditional knowledge. We all know about it. So please revoke the patent, and the patent is revoked. Basmati rice, right? These are all our traditional knowledge. Someone grows basmati rice in the US, and can they patent it? They cannot. So in India now we have something called as TKDL, Traditional Knowledge Digital Library. So now all our traditional knowledge, they have compiled and made it as a digital library, and that we use. And if someone else in the other developed countries, if they are going to use any of these traditional knowledge, then we say, this is not novel. This is already there in our traditional knowledge digital library. So they can't patent it. Okay? Okay. Then what happened is, the one landmark case in the US, it happened. One very important case. It is called Diamond versus Chakravarti. Diamond is a commissioner. His name is Diamond. And Chakravarti is a scientist in India. He was working in GE those days. What happens is, you all know, right? Oil spills. In the water, when ships or something happens, or when they are extracting oil from the ground, oil will spill on the sea, right? And when oil spills on the sea, the aquatic life will get affected. All the fish will die, all the tortoises will die. So we need to clean the oil spills. So this Chakravarti came with an idea. He found a bacteria, and that bacteria can eat the oil. So very happy. We are able to clean the oil spills. Good solution, no chemicals, nothing. Just leave the bacteria. The bacteria will go and eat the oil, and the sea will be cleaned. Very happy. Everyone was very happy. So he went to the US patent office and he applied the patent application. He applied for 3 claims, 3 patent applications. One is for the process of making the bacteria, and the second one is something to make the bacteria float on the water, right? Bacteria has to float on the water to eat the oil. Oil floats on the water. So he came up that. And third, he claimed patent for bacteria. Then US patent office said, no, bacteria is living thing. It is naturally occurring, you can't patent it. So they fought with the patent office, and there are levels, like district court, high court, Supreme Court. Like that, we also in patent office also we have. If you are not happy with patent office decision, you can go to appeals in the US Court of Appeals. Then you can go to the Supreme Court. Generally, Supreme Court will not too high, right? The topmost court. It will not hear all the cases. But this case was heard by Supreme Court. Supreme Court had interfered. and said whether bacteria is patentable or not. Bacteria is a living thing, it's cleaning the oil spills, can we patent it or not? You know what Patent Office said, what Supreme Court said? Supreme Court said, it is not just bacteria, it is he made so many changes to the naturally occurring bacteria. Human intervention went inside. It's not just like that he picked up from soil and put it in the thing. He brought the soil in the lab, he did something, he modified the organism, so he said it is creative creation, it is not discovery. So there is a difference between innovation and discovery. Discovery is, you are unlocking something I discovered. That is not patentable. What is innovation? Human intervention is there. I brought something from the soil, I brought it to the lab, I did some experiments, I modified the microorganism, so that is patentable. There is the first landmark case all over the globe which said that living organisms can be patented provided human intervention is there. Okay? We have a case in India also. Okay? He developed a vaccine for treating the poultry, Dimanaco. In 2012, he developed a vaccine for treating the poultry. Again, Patent Office said, you have a vaccine, but that vaccine has virus, the virus is living, this is not patentable. Then again, in our case also, Supreme Court said that, what are you selling at the end of the day? I am selling the vaccine. Is it saleable? It is saleable. So he said, this vaccine is patentable. Okay, I think I should skip this. I will just very briefly talk about claims. Now we have a patent application. You are constructing a house, right? How do you say this is my house? You define, right? This is my border, this is my compound wall, this side I have east side Ramappa states, west side something else says, like that we define, right? For your invention, these are the claims are the ones which define the metes and bounds. So claims are extremely important. So that's how we draft. If an inventor comes to me, first I'll understand and I will draft the set of claims. Claims means these are no one can infringe, no one can copy this part. So if you can define the whole invention in the form of claims, that is patentable. So for that that's the reason why I just told you initially that no one can be a patent attorney unless they have some technical skills. So to understand, you come up with you come up with this much invention, I'll try to protect. You said I invented a bottle, I'll try to invent and you say plastic bottle. I will not say plastic, I'll say Aditi invented a bottle made of any material. So I don't want to say plastic. What will happen if I say plastic? He can make with steel bottle and tomorrow he cannot infringe. He can copy your invention just by changing the material, right? So claims are very, very important and you have to be a technical, it is a techno-legal document. Basically, patent application is a techno-legal document, whereas technology also goes into that. So claims define your metes and bounds. So these are, I think I should skip this. It will be too much for you people. So how do we draft the claims? This basically it says how we have to draft the claims such that we will be able to overcome all the rejections of Patent Office. I think it's too much for you. It's not necessary. We can go off directly to, yeah. Now, as I initially mentioned, the minute we talk about vaccine, we have polio vaccines, we have flu vaccines, we have everything is there. But of late, we are hearing mostly about vaccine is nothing but COVID vaccine, right? We all went through such a bad phase in 2020. 4 years passed away, but we still those things. A few concepts I wanted to introduce. That's why I went back to the history of 2020, and I wanted to tell you about COVID vaccines. COVID completely changed the world scenario, how the research happens. It's so much of things we all know, right? Some people went depression or into, so much of isolation, so many things happened, and how the research happened in that. Okay, when did it happen? December 31st, 2019. Who was informed from Wuhan? There are cases of some kind of pneumonia disease was there. The message reached WHO in 2019, December 31st. Then they identified it's a virus, and we named it as coronavirus in 11th February 2020. Then immediately WHO alerted everyone. They said all of you have to jump in, you have to start research, and you have to develop some kind of diagnostics, some kind of vaccines to stop the disease, to control the spread of the disease. Okay. All the borders were sealed, no travel happened across the countries, everything, you can't enter, but that's when the scientists broke their records. Generally, how the scientists work, they work in isolation. The professors especially work in isolation because if they don't get grants, they will not be able to continue the professorship in the especially developed countries. So they do their research in secrecy because they want their research not to be known to others, right? Because they have to get grants, they have to get tenures for their life, no? That is this thing. So they used to work like that. But COVID completely broke. All over the globe, the scientists came together and worked on only one problem. How do we contain this virus, right? So this is one case, one such an example where the research happened globally without any closed doors. That's what it says, right? Political leaders locked, but scientists broke. They all worked together. See, now what did they decide? What was the mantra those days for our COVID time? Ability to work collaboratively, setting aside personal goals, and that was the order of the day. I have to work together, I have to work collaboratively with others. Okay, so the data, we need to develop a vaccine, we need to know the sequence of the virus, right? The virus has to be known. China published the virus globally. It is available, it was made public, the sequence of the virus was published. The scientists started working on the COVID-19 vaccine, and see how the last one is really interesting. One lab from Pittsburgh worked with one institute in Paris and one in Austrian drug company, and that was funded by Norway. That was money was given by Belinda, and they talked to the Serum Institute of India. See how the collaborative research happened all over the globe to solve one problem, because that is a survival, right? I can get my professorship later. But to get my professorship, I should be alive. I should be live, right? So they all work together. Not only industries, not only institutions, industries worked. Pharma, big giant pharma industries came together. They collaborated. GSK, the GlaxoSmithKline, it's a very big pharma company. They worked with Sanofi. They worked with University of Queensland. They worked with Canadian. Everywhere, I mean, they just broke the borders and they started working together. Then another example, not only vaccines. India was acute of, you remember, right? ICU, to get the ventilators was so difficult. So MIT has developed one low-cost ventilator. A software company from Pune, they have jumped up, they took the open source and they started developing the ventilator. And who was coordinating the whole process? One cardiologist from Bangalore. So MIT, Boston, US has developed the ventilator, picked up by Pune startup, and guided by a cardiologist in Bangalore to develop the ventilators to help Indians to fight the disease. So this is the background of COVID vaccine. Okay, now, right, all done. Now we know that by manipulating the language, I can get the patents for vaccines, and corona vaccine was developed. There is something called as patent waivers. We'll understand. Before that, I just want to tell you something else, compulsory license. What did I tell you before? If you have a patent, no one can practice. But in some cases, government can jump in and say, Ramni, stop. You give him, let him practice your invention. Let him do this happens only for pharma cases. In pharma industry, if you have, government can interfere and stop the inventor and give to someone else to make. I'll just give an example. Bayer is a US company, they're a pharma company. They have invented a drug called Nexavar. The drug is for treating the cancer, liver and kidney cancer. They have a patent in India, so no one can practice. What they are doing, they are bringing the medicine from US and selling in India. No one can make it because they have a patent in India also. So how much is costing? Around 2.8 lakhs per month. How many people can really afford 2.8 lakhs? Then government said, Bayer, you stop, you let Natco Pharma of Indian company, let them make the drug. They are making the drug for 8,800, around 9,000 they are making, versus 2.8 lakhs. So this is the first compulsory license. See, you understand here now, Bayer has a patent, no one can practice the patent, but in this case, government has jumped in. This is basically for healthcare. Okay, again, NATCO cannot make medicine sell outside, right? NATCO can make only for Indian population who needs the drug. But Bayer is completely at loss? No. NATCO has to pay them 6% royalty. For every medicine they are selling, Bayer gets its peanuts, but at least they are getting something. This is called compulsory license. What happens compulsory license? You have a patent, but sometimes government can say, stop, let them also practice, because it is our important condition is right to health, right? We have a right to health, so government can interfere and can stop. Very rarely. This will not happen in any other case except for pharma. Okay. That is compulsory license. What is the second thing is patent waiver. In compulsory license, government will interfere and tell you, if you have a patent waiver, you don't even, patentee will not get anything. Pfizer has a patent in India. If they give the patent waiver, anyone can practice. But Pfizer will not get any money. This is patent waiver. Who started this? Again, we only in India and so all the developing countries. In 2020, they went to the WIPO and they said, they went to WHO and they said, please waive the patents. I should be able to, everyone can make the patents, please waive the patents. Okay. Now let's see that. What for any pharma industry, let's see both sides of the coin. Now let's see from pharma industry. If you have a pharma industry, to make one drug, to first identify, I have cancer. I have to find a drug. So to identify from that stage to develop a drug for the cancer, I need 20 long years. Not 10 to 15 years, sorry, 10 to 15 years, a drug is, time needed for developing a drug is around 10 to 15 years. How much money will go in, how many efforts will go in, how many scientific hours will go inside. So that is pharma's argument. If you don't give monopoly, if you don't give me patent application, everyone will practice after 15th year, right? The drug is available, they'll reverse engineer, they'll break the drug, they'll find out and they'll start practicing. Pharma industries will be at loss. The investment cost is very high. I'll just show you one part. See, from research to development, it will take around 8 years. There are the probability of success for it to move forward will be 10%. Most of the drugs will fail. So how much investment is needed? How much risk is available? Risk is there in those inventions. So how do you recoup your money? If you give patent waivers, if you let everyone practice on their own, what will happen to your money? How will you get motivated to move forward? How will the pharmaceutical industries go forward? I'm not talking about our computer science industries. I'm not talking about any other industry. This is especially for pharma. Pharma also has a point when they said they don't want. Developed countries, as usual, when we fought, India and South Africa asked for patent waivers, developed countries said, no, we will not give. But how will we recoup money? So that's not their point. Okay. Then what will happen? These are the disadvantages, right? It will discourage the pharma industries. It will lead to financial losses. And whole drug industry, the whole idea is, I'll invest money, I'll get back money for 20 years. My drug is released, I have money for 20 years for the entire treatment. That's gone if you give the patent waiver. This is the point. Okay. All right, everything is correct, but there is a small hitch here. For COVID vaccine, so much money went, public funds went in. It's not only pharma industry, right? So much public money also went in. So many NGOs contributed. Like you remember, polio vaccine was developed by Jonas Salk. So they all asked for polio those days, right? So they all asked, why did you not patent? Then he said, can you patent sun? He asked the question. The Jonah is very, very important book also is there. Can you patent sun? Right. He can afford not to patent his polio vaccine. You know why? Billions of dollars went in developing the vaccine. He didn't spend anything. So much money was pumped in from outside to save the children. So that's fine. So here also COVID vaccine, there is an argument that COVID vaccine, when it is developed, a lot of public fund went inside. It's not only pharma money, lot of NGOs, lot of public money went in, so they can open it to the public. Anyway, the problem solved now. So, right, patent waivers are given. But is that the only solution? If, okay, I give the patent waivers, will you be able to start the drug tomorrow? How much? You need to know how. You need know-how, right? Okay, if there is someone is learning cooking, so mother tells, put the rice, put 2 times of water, and the rice will get cooked. The girl was waiting, putting rice and water, the rice did not get cooked. She asked, Mama, right did not happen. Why? You did not switch on the stove, right? Mummy didn't tell you that. She thought it knew not. So it's not only the thing, you need to know the know-how. To get the rice cooked, you have to switch on the gas stove, right? That girl did not know that she put rice and water will not happen. Same way, if Pfizer gives the vaccine patent to us, and it has something called as very, very special technique called as mRNA technology. It's extremely skillful. You need technicians, you need skillful people to do that vaccine. So if I just gave my patent, and can you practice it without knowing the know-how? It is not possible. So just patent waivers will not solve the problem. That's what I'm saying. Okay. So you need skillful labor. Where is that in India? Where is it in the developing countries? And you have to monitor from dose 1 to dose 2. We did good. Okay, we all got SMS. You finished your first dose. I don't know whether maybe people were not even eligible. I think you are under 18, right? When COVID period, I think they wouldn't even have been eligible for COVID vaccines. So we used to get first vaccine, then we used to get reminders. We did well, but it's not. Patent waiver is not the only solution. That's why let's not be blind and keep on asking for something which will really not solve the problem. So by giving patent waivers, tomorrow corona vaccine will not be developed in India. We need facilities, we need skillful labor, we need technicians, we need scientists to happen that. That's what it says. So there are alternatives. So we need know-how. Just giving patent alone is not enough. We need to give all the details. We need to come and train the people to make the vaccines. Okay. There are other alternatives. Patent waiver is not the only thing. There are other alternatives. What did they do? AstraZeneca, they have given the licenses. They came to different sites, they gave the license, they stood behind, and they make the vaccines. And Moderna did not enforce the patents. Moderna has a patent application, but they did not enforce. They did not go whoever can make the patent, they said, make it during the pandemic. And Sanofi arrived agreement with someone to make the doses for Europe. And Russia gave us Sputnik for free of cost. These are the different models. Patent waiver is not at all only solution. That's what I'm saying. There are pros and the cons. Okay, with that I will stop. So just what we learned today is about patents. Patent is an invention. If it meets 3 conditions of novelty, inventiveness, and industrial applicability, you get a patent. When you get a patent, you have monopoly for 20 years. No one can copy your invention. No one can practice without paying you money. So you get licenses, you get royalty from them. That is what patents. Then we learned about vaccines. Vaccine can be patented provided there is some human intervention. It can't be just virus picked up from the soil, from air. That is not patentable. But if human intervention, a person tweaks the naturally occurring microorganism, he puts his engineering knowledge and alters the microorganism, it is patentable. And we learned about compulsory license. Compulsory license happens in India for pharma drugs, pharma cases when it is needed. Patent waivers also possible, but that is not the only solution, right? These are broadly what I wanted to cover. So with that, I'll stop. I'm here for questions now, or if the organizers doesn't permit now, we can take it later also. Anytime you can, I was teaching once, so I like to be a teacher. So anytime you have any questions with the patents related subject, you can always approach me. My number is there with Dr. Indranil. Please feel free to call me anytime. Thank you very much.
Thank you so much, ma'am, for the passion and compassion personified in the presentation, and the rigor with which she was very clear that, yes, these are the areas that I should be touching upon. Thank you so much, ma'am, for the subtle and the brief and the effective presentation that you have made. It's my delight to introduce our chief guest to the audience now, Chief Guest Justice Dr. Vineet Kothari, former Acting Chief Justice, Gujarat High Court. Sir is currently designated Senior Advocate by the Supreme Court of India and practices law in constitutional courts in India. His main areas of practice are domestic tax laws, international taxation, arbitration, corporate and insolvency laws, property and Come professor in the Faculty of Law, J. Narayan Vyas University, Jodhpur, for about 6 years from 94 till 2000. Sir, it is my honor to invite you here, and we are eagerly waiting to listen from you. Thank you so much, sir, for being here with us.
Very good morning to you all, friends. Director Ajit Saab, Madam Ramni, Dr. Ramni, Indranil Saha, my friend, people from industry, and faculty members, teachers, and dear students. I really feel honored and happy that I was invited to be part of this symposium today. And I traveled from all the way from westmost part of the country to the southmost part of the country. And with the 5 hours flight delay yesterday, I had hardly 5 hours sleep by now. So anyways, I'm as active and agile as I could be. And it's an honor to talk about something about the latest technology and thing. I don't know whether you will take home something to preserve property. And of course, but I've been given a right to speak for a few minutes, 10 or 20, and you have a corresponding duty to listen also. So I'm happy to be here. I'll be talking something about the various developments in the field of AI, artificial intelligence, which is the main core of the theme today, and the various countries who are updating their laws and regulations to regulate this field. Because ultimately IPR registration, patent, trademark, and all this is ultimately to monetize your knowledge, your innovations, your inventions, and something new which you have created, to earn out of it by way of royalties and all that. AI, as you know, of the last few years we've been hearing, it's a disruptive technology and is a game changer, as everybody knows now. Section 15 of US Code defines in Section 3B, artificial intelligence as under. Just for your knowledge and perspective, what is AI? Everybody knows that intelligence in an artificial form is artificial intelligence, but then law is now trying to catch up and define and probably broad and undefinable thing, because the technological developments which will take place at the rapid speed in this field will perhaps leave the law catchers to be catching up with them in the times to come. Anyways, the US and Europe has taken a lead, and they define AI like this: a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. This is code 2358 of notes in US 10. And any artificial system that performs tasks under varying or unpredictable circumstances without significant human oversight, or that can learn from experience and improve performance when exposed to data sets. So if something is happening without human interface, intervention, or involvement, and it's happening artificially, though the original inputs are developed by human beings, but then a mix of all that, which is brought through machine, that is artificial intelligence. And that is why the problems in the legal field are arising, whether to patent AI products or not, or process or not, without human interventions. And the law as of now, despite these definitions and EU enacting Act number 24, Act number 2 of AI Act 2024, EU, they have not, the courts have not so far sanctified the grant of patents to AI products without the human intervention. And there are 2 or 3 famous cases which I'll be talking about that. Article 2 of the AI Act 2024 states that it will apply to AI providers for services in European Union, irrespective of whether the providers are in EU or in third country. Hence, any footprint of use in the EU is necessary for the liability to attach. Article 3.1 defines an AI system as a machine-based system designed to operate with varying levels of autonomy, that may exhibit adaptiveness after deployment and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can be influenced physical or virtual environments. Who is an author? This becomes very relevant in these AI days, whether the author is human original person who created that artwork or the science work, or whether the machine which created that. The requirement of the intellectual creation means the only works created by natural persons can be protected by copyright. The link of the intellectual character to a human author may be less direct, but it is no less important according to the key test. The requirement of an individual character, if met, is met if no other individual would have created an identical or highly similar work. The human being is also the key figure for copyright ownership, as the original right holder is always the author, that is the natural person who created the works, created the work. Indian Copyrights Act 1950 section 2D, Roman 6 defines author to include, in relation to any literary, dramatic, musical, or artistic work that is computer generated, the person who causes the work to be created. Patents Act 1970, where AI systems have been excluded from the ambit of applicability of the Act, thereby restricting the rights of the person as evident in section 21P, section 21T, where the patentee is referred to as a person, and section 61A, which states that an application for a patent can be filed by any person, and also section 21JA, which defines inventive step, an essential requirement for an invention to be patentable, and such invention must not be obvious to a person skilled in the art. Madam was talking about non-obvious things to be patented, and rightly so. The United Kingdom Copyright Designs and Patents Act 1888, CDPA, section 9. I'm reading this just for a general knowledge so that you have an idea of how different countries are trying to grapple with and update their laws to bring within their ambit and fold the regulations applicable to this disruptive technology. Section 9.3 states, in the case of a literary, dramatic, musical, and artistic work which is computer generated, the author shall be taken to be the person by whom arrangements necessary for the creation of the work are undertaken. And section 178 of the CDPA has defined computer generated work as generated by computer in circumstances such that there is no human author of the work. Likewise, the different companies are not narrating all. The human intervention and cooperation with the machine has been considered necessary for patentability in the present era. A case arose for this remnant painting through 3D artificial generative AI created artwork through utilization of the ML process. In the next Rembrandt, a 3D printed painting created after analyzing the works of 17th century Dutch artist Rembrandt Hermanzoon van Rijn. This artwork was created with the collaboration of various persons and entities along with the AI system. This creation raises crucial questions for the IP laws across various jurisdictions, as there will be more such cases in the future where IP laws will be needed to address such issues for the proper determination of rights of the AI systems and the natural persons. My research team also did a research on the Starry Night painting, famous painting, which was created in different forms with AI. And courts are now getting these kind of cases, all jurisdictions, whether to grant or not to grant patent to them or copyright to them. The another interesting case is in the name of Dabus, D-A-B-U-S, as in US district court so far. The case was there that interestingly across various jurisdictions such as Australia, the United Kingdom, the United States, New Zealand and the European Patent Office applications filed by Stephen Thaler to patent the invention by his AI systems known as Device for the Autonomous Bootstrapping of the Unified Sentience, DABUS. Device for the Autonomous Bootstrapping of Unified Sentience. Bootstrapping, they say, when you are doing with the minimal resources, like you strap your boots, shoes. So in your own garage room, you created your own machine and you created this kind of thing. Whether he could be granted this patent. So he claimed, but the ultimately US District Court rejected it. But the South African, they find an exception. As the South African Companies and Intellectual Property Commission, CIPC, accepted Stephen Patent Cooperation Treaty on 24 June 2021 for a patent in respect of inventions made by the Dabus. In July 2021, CIPC released a notice of issuance of the patent, and Dabus became the first AI system to be regarded as an inventor and granted a patent for invention. So that is a solitary exception which is so far found in our books. Another similar case arose in the name of Raghav. Raghav has nothing to do with India, it arose in US. Like Dabus, the Copyright Office in India, it was granted here by mistake. Albeit mistakenly, has recognized an AI system Raghav as the co-author of an artistic work and registered the application for copyright application. However, in the first instance when Ankit Sahni, so it was basically Indian, yes, the creator of an AI system Raghav filed the application listing the AI system as the sole author for such work, had the application rejected by the Copyright Office. Later, the Copyright Office issued a notice for withdrawal of such registration, as it had mistakenly granted the registration and asked the human co-author, Mr. Sahni, to deliberate upon the legal status of the AI system Raghav. The application status is still displayed as registered on the website of the Copyright Office, but the court is yet to decide the issue. The decision of the court holds strong significance for the issues that surrounded AI system and IP laws regarding copyright protection in India, as will act as a precedent for similar cases in coming times. So the disputes are already on. Now the case of this Mr. Stephen Thaler went to United States District Court, and it dealt with it like this. By an order dated 18th August 2023, in Stephen Thaler versus Shira Permulator, Registrar of Copyrights and Director of United States Copyright Office et al., the principal issue of whether work autonomously generated by an AI system is copyrightable in the United States was discussed and decided upon. It was concluded by the Honorable Court, after deliberating on the issue, that the Copyright Office acted properly in denying the copyright registration for a work created without any human involvement. Mr. Stephen Thaler, the owner of the computer system called Creativity Machine, capable of producing artworks independently, filed for a copyright to register the work created by computer machine, listing it as the author and requesting that the copyright be granted to him as the owner of the computer machine. He said, I own the computer machine, therefore I am ultimately the author, and therefore you grant me the patent. It was rejected. The application was denied by the Copyright Office on the ground that the work did not have human authorship necessary to support a copyright claim. The Honorable United States District Judge Beryl Howell in this case discussed the issue in the light of Copyright Act 1976, which provides copyright protection to original works of authorship fixed in any tangible medium of expression, no known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. The fixing of the work in the tangible medium must be done by or under the authority of the author. So in order for the work to be eligible for copyright at work must have an author. The word author is not defined in the Copyright Acts of 1976, definition of which of the term as taken from the dictionaries defines it as one that is the source of some form of intellectual or creative work, and the creator of an artistic work, a painter, photographer, filmmaker, etc. The literal interpretation of the statute was concluded by the judge as, I quote, by its plain text, the 1976 Act thus requires a copyrightable work to have an originator with the capacity of intellectual, creative, or artistic labor. Must that originator be a human being to claim copyright protection? The answer is yes. This is how the Stephen Thaler's case was decided by US District Court so far. I think it will be taken further as usual, and the superior courts will also have to decide that. Now, invention or inventorship in patent law is also very important, as previous speakers have explained. I'll just read a small part of it. The question of whether the patent law can be or should recognize AI systems as inventors if they generate otherwise patentable technical solutions without an invention or contribution by humans is arguably the most conspicuous issue in the current AI/IP landscape. A need to definitely assess whether the human contribution to an invention relative to a contribution made by AI systems is sufficient to establish human inventorship, and thus patentability unnecessarily harms legal certainty and uses patent office resources. it is one of the functions of the patent system to instruct the public about the progress of innovation and thereby to induce further innovations, for instance, in the form of follow-on inventions, necessitating the patent application to disguise the true relation between human and AI contribution to an invention, as can happen very easily. Because they must otherwise fear that their application will be rejected, hampers this function. Such impairment becomes even stronger where AI-generated inventions are not submitted for patenting at all, but remain confined to the realms of trade secrets. Recommendation by some authors are like this. Where an AI system generated inventive output without inventive human intervention, the patent application should be permitted to say so and name of AI system as inventor along with the natural person or legal entity who claims ownership of the patent application and a resulting patent until legal rules have, where necessary, been changed to accommodate the above recommendations. The natural person should, as a temporary workaround, be allowed to act and register as proxy inventors as long as they disclose this role at the AI system for which they act as proxy. Such disclosure should be provided in the description. So this is more an argument from the side of the persons who are seeking patents for AI generated with cooperation of human beings to allow them to get that patented as original author themselves or machine owners themselves, and then the product with the AI cooperation. Now, some Indian case laws, I'll just give a brief reference so that you have idea. In Christian Louboutin versus the Shoe Boutique, Delhi High Court on 22nd August 2023, Justice Pratibha M. Singh, whom I know for sure is an expert of this field, she decided in a case where the Christian Louboutin suit against the seller manufacturing shoes with similar designs in various malls in the national capital and other states, the luxury shoe brand alleged that Shutik, the defendant, was manufacturing shoes with the same get-up and identically copied shoe designs. The court recorded the statement of one of the partners of the defendant firm that the shoe designs were used on a made-to-order basis and the company will not imitate the copy. They virtually gave up, that will not copy it further. Manufacture or sell any shoes which were imitative of the Christian Louboutin's designs in future. The Delhi High Court said that in this case, the response of a large language model based chat box, which you chat GPT and all this you get, such as chat GPT, depends on a host of factors, including the nature and structure of query put by the users, and thus there are possibilities of incorrect responses, fictional case laws, imaginative data, etc. to be being generated. The court refused to rely on chat GPT response in a suit filed by French luxury company Christian Louboutin over its unique red sole shoe design. The Delhi High Court has said that artificial intelligence cannot substitute either human intelligence or human element in the adjudicate process. So far so good. They have said that human resource, human intervention, human cooperation is necessary to get your patents and copyrights done. Solely on AI, you can't get that. Another Delhi High Court judgment which I'll talk is Radion Company versus Controller General of Patents. The judgment highlights the challenge of applying traditional intellectual property rights framework to rapidly evolving fields like emerging technology, as seen in the reliance on outdated guidelines from 2016. In this context of emerging technologies such as high-performance computing, HPC systems, patent examination criteria need to be adaptable to accommodate innovations driven by software, advancements and algorithmic improvements. Clear and consistent guidelines are essential to provide clarity and direction to patent examiners dealing with emerging technology, focusing on technical contribution rather than rigid requirements like novel hardware. Now, these is a brief idea about the case laws or the litigation which is developing or has developed, rather is coming in the courts regularly. Now, different countries, of course, have not very different, very polar, different poles on that, but the law is developing on these lines in the present era of AI and all this. And therefore, it is for symposiums and seminars like this, and the students like all of us of law, we must understand, as Madam rightly pointed out, technology also, and the nature of technology development combined with the constantly updated laws and regulations is the main crux of the matter. And for law students like us, we must understand both aspects of the matter. Then only you can either successfully get that patented or copyrighted, or even if you fail, you can argue your matters in the courts of law. Because, and on the other side, when I talk of judges and right from district court to constitutional court up to Supreme Court, even we judges have to update ourselves on a regular basis. Because unless a judge is trained enough or knows the development of the day, he can't decide what is right. The very exercise of interpretation becomes relevant unless the judge is properly trained. And that is why we have all these states judicial academies and National Judicial Academy at Bhopal, where I am a constant visitor always, and earlier as a delegate, now as a resource person. Now let me talk two aspects which I wanted to talk to young friends, all faculty members also. Being a tax side person, I also know whenever you earn out of something, including IPRs, there are always taxing provisions to tax it. Now, our Income Tax Act, as I have been dealing with last 40 years, is typically the most complex tax law on the earth. And for as small, small in the sense, one part of the law, IPR, which we are discussing here, there are at least 10 sections in the Income Tax Act which are relevant. I'll just give you a number and you will be kind of mind-boggling. Several sections deal with the taxation of IP rights under the income tax law, such as section 32, 1, Roman 2, 35 capital A, 35 AB, 80 GGA, 80 O, 80 QQA, 80 QQB, 80 RRB. Now, are you not amused by these kind of sequence of provisions in the Income Tax Act? We amend our income tax law every year with the Finance Act, budget, as you know. And I have been, though I am a chartered accountant and a tax side person, but I have been highly critical of the constant amendments of income tax laws to make it more and more complicated every year. There is no need of doing this. They can create separate scheme for the industry targeted or SSE targeted schemes to make the things much simpler, and the schemes can be read mutatis mutandis with the Income Tax Act, which can be contained in as short as 100 sections. But this all ABCD included, I think there are more than 1,000 provisions in the Income Tax Act. Now these sections deal with different aspects of your earning out of your IPRs. They deal with you some incentives, depreciations on your investments. They deal with your deductions from the income on certain eligible conditions being satisfied, like section 80 in chapter 6 of the income tax deals with deductions. 35 are investment into scientific research and all that, that is also deductible expenditure of the income tax law. So income tax law is generally amended really to give you incentive and incentivize your scientific efforts also. And you make you a separate class of people who will pay the least of the taxation subject to certain compliances once you start working in the IPR field and start getting them registered, patented, copyrights and all that, trademarks and all that. But the Indian courts, as you know, and we lawyers, of course, are beneficiaries, but they are full of so much of workload that when you enter the court hall, you feel very fresh and strengthful. But when you come out after 20, 30 years, you are already exhausted, money-wise and resources-wise, and till you get a final decision if you are lucky enough. So this was just aspect to give you an idea that tax laws are also important for you people as professionals to know that once you are dealing with IPRs, your tax laws compliance will also follow you like shadows, and you will have to be there. The another aspect which I wanted to touch as a guest speaker is the accountability and audit of the whatever you spend for your research and whatever you earn out of it. Now, taking a pharma industry for example, I was talking to some of the friends here, that how do you say our research cost is very high and your market relation is very high. For a layman like you and me, the allopathy medicines are very, very costly, and the same generic medicines you can get in 10 rupees, you can get in 1,000 rupees, 10,000 rupees. They may be justified in saying 10,000. But if the same disease is cured by a 10 rupees medicine also, why should anybody pay 10,000 rupees? So what is the difference? What is the cost relation to that? Can the public demand all this data in public domain? Is it a part of the accountability to be fixed through law on the industry, who under the right to earn out of their registered IPRs should realize all this? There is a need to introduce accountability and proper audit of all this also. Perhaps to my knowledge, Even if regulations about costing and all these are there are some cost accountants also sitting here. I was talking to a friend, faculty member. So costing is done, but how much public is made aware of that? Your research cost, you may say X. X can be 10,000 rupees. The other fellow, the same disease cure may be selling in 10 rupees, as I said. So whether you are not responsible to tell the public that this is why my 10,000 is justified. If you justify it and if you show the difference, that 10 rupees medicine will not do the same thing as my 10,000 rupees medicine will do, but possibly you are justified. But as a lawyer and lawmen and women, we should understand the difference. And as a chartered accountant, I would also request, and there are accounting standards about IPRs settled by the ICAI, of which I am a member, Institute of Chartered Accountants of India. So you have to, compliance part as lawyers, you will have to ensure that IPR industry or IPR professionals are not in a cocoon or silos when they talk about total compliance regime by the industry sector. So, because you will be advisor to these people, and you can't claim or plead ignorance. As far as I am concerned as a judge, I got opportunity to decide one case in Madras High Court Division Bench on somewhere in 2019, yes, 2019. And the very simple issue was whether this Patanjali biscuits, Patanjali has been in news for recent times, you all know. The one company, Hudson Agro Products, was selling its products, food products. Hassan Prado filed suit against respondents Patanjali Biscuits, and Patanjali Biscuits alleged infringement and passing of its product as that of the plaintiff by using the offending trademarks Arogya, AARO-GYA, Arogya we know, without disease, which are similar, deceptively similar and identical to plaintiff's trademark Arokya, AROKYA. Now Arokya and Arogya doesn't sound deceptively similar. So when you deal with judges, these words catch your eye and attention in the first instance. So the moments the lawyers before us said Arokya and Arogya are deceptively similar, I said it doesn't sound like that. So please explain your case. So when they explained, so we came out with the conclusion that the learned single judge whose order we were dealing, he rejected the injunction given in favor of this Hudson company on the basis of Arokya, which was his trademark, that Patanjali biscuits cannot manufacture Arogya biscuits, and therefore you injunct them. Then ultimately the stay was rejected and we upheld that order. What I mean to say is that at the High Court level and Supreme Court level, these cases come at a much later stage, when the process and all this litigation is passed through many areas and courts below. But then as lawyers, what is of importance is that you catch hold of the crux of the matter first. You understand the technology behind it. You understand the AI put into this. You understand the human interference, inventive steps, all this taken for getting those things done. Because courts will always reach to the roots and then decide whether your claim on the particular IPR is justified or not, whether your gain out of it, qua the other side who is claiming similar right, is justified or not. Court ultimately decides on the basis of balancing the interests, fairness and transparency. So, friends, that is all I wanted to give my thoughts to you as a former judge and as a lawyer now. And one more aspect is that ADR is a field which will be of great relevance in our country as well as the international scene in IPR laws also, in presently also and times to come also. Because as far as Indian court legal system is concerned, going into it is easy, coming out of it is generational thing. Therefore, जो हिंदी में होता था ना पहले, मैं तुझे कोर्ट में देख लूंगा, अरे भाई देख तो लेगा, कोर्ट के बाहर देख लेगा, अंदर से बाहर आएगा, तब तक तू भी नहीं देख पाएगा, मैं भी नहीं देख पाऊंगा, नेक्स्ट जनरेशन देख पाएगी। ये मजाक की बात भी नहीं है, ये इतना सारा वर्कलोड है इंडियन जुडिशियल सिस्टम पे कि वो डिसाइड करते हैं, तो इतनी हिरार्की है उसको फाइनली डिसाइड करने के लिए, that ultimate relief, ultimate justice as you call it, becomes a mirage, kind of mirage, and it's a costly affair. Therefore, ADR, alternative dispute resolution through arbitrations, mediations, which new Mediation Act now we have in our country also, is the forum, is the era, is the remedy which you as legal professionals should suggest to your clients, advise them, and probably through that system you will get your dispute settled in a more fair and transparent manner, and probably bringing more peace to the resolution of dispute, because peace is very necessary for any development, as you know. So thank you for inviting me and giving me an opportunity to be with you and address some of my thoughts to you. I hope you will find them at least of some use in your future career. Thank you.
Please stay back, we will have a photo session.
Okay, I stay. So I'll keep it here.
Yeah, sure, please. Thank you so much, sir. And it was really great for having touched upon different aspects and the interface of ADR, commerce, commercial transactions, technology, and everything, and specifically with regard to the Income Tax Act, which is very much near to your heart and your passion. Thank you so much, sir, for your expertise. We are grateful to you and your insights. We really know that the gratitude is all about, not about appreciating, but living it up to it. And we definitely and constantly request you to support us throughout our ventures and activities and throughout the growth process at Manipal Law School. Thank you so much, sir. Now may I invite all the panelists to come onto the stage, and also faculty from MLS for a small photo session, so that we will not miss out on those moments. Please. I request faculty as well from MLS to join us. After this, students, all of you can now go for the tea break. Now we will be having the tea break for 20 minutes. Please join back diligently, and we'll be having our roundtable discussion, panel 1. So please. Please, sir. Please come forward, sir. Hello, sir. Please come forward. Please, ma'am. Please, ma'am. Yeah, yeah. I'm already done. Yes. No, no, no. We want the photo with you, ma'am. Please. Where to stand? You stand in between here and there. Malik, come. Rahul Mishra is not there. Come. Go down. We'll go and this captain. Yes, because you will not be able to. Welcome to the roundtable discussion, panel 1. The topic for the panel, may I request the students to switch off your mobiles or keep it in the silent mode? So panel 1 discussion is happening here. The topic is AI in the domain of pharma and biotech and its implications. Yeah. The panel 1 discussion will be on the topic AI in the domain of pharma and biotech and its implications. It's my privilege to call upon the panelists onto the stage. I call upon Dr. Amar Rajendra Desai, General Manager, Global IP, API CIDES. Sir has PhD in Medicinal and Pharmaceutical Chemistry, PG Diploma in Patent Law from Nalsar, Hyderabad, and Sir is associated with the IPR Management Group at CIDES for more than 18 years. I request Dr. Harish Chandran, Head of IPR and Licensing India, Novenesis, and Sir has MSc in Biotechnology from Center for Plant Molecular Biology, Tamil Nadu, PhD from CCMB, Hyderabad. Sir is a registered Indian patent agent with a PhD in biology and work experience at the patent office and in the industry. And the expertise is in the areas of patent drafting, searching, analysis, patentability, freedom to operate, etc. Now, may I request Mr. Chirag Soni, General Manager, Global IP, Formulations, CIDES. Sir has bachelor's and master's degree in pharmacy and LM College of Pharmacy, LLB from Gujarat University. Sir is a registered Indian patent agent, and the skills revolves around patent law, patent infringement analysis, patent drafting, patent prosecution, and patent litigation. I invite Mr. Amitabh Mishra, Head Biotech Division, Deputy General Manager, and in charge Legal, NRDC, Government of India. Sir has MTech in Applied Botany from IIT Kharagpur and has mentored more than 400 bio startup and commercialized more than 100 biotechnologies. Now I invite Dr. Vikas Agarwal, General Manager, Global IP, Unison Pharmaceuticals, who is the moderator for this session. Sir has M.Pharm in Pharmaceutics, PhD in Pharmaceutical Sciences from Charusat, PG Diploma in IPR from Nalsar, Hyderabad, MBA from Narsi Munji Institute of Management Studies, and the skills is around creative and experienced business professional with nearly 14 years of experience across broad range of pharmaceutical major business activities such as portfolio planning, product launch planning, and calendar management, market forecast, and trend analysis, etc. It's with pleasure that we have the moderator and the panelists, the speakers over here. Now over to you, Mr. Dr. Vikas Agarwal. Thank you.
So first of all, I would like to thank you to Manipal universities and specifically Dr. Indranil for inviting us on such a great sessions, right? And I also welcome all the panel members who are here, who are spared their valuable time for these discussions, right? We will start, from here or from there as you wish, right? So this is very interesting topic today. The AI impact in pharma and biotech industries, right? So just to start with, so how do you see, the AI impact in coming time in pharma and biotech industry? What is, going to be the most important role of AI in pharma and biotech industries?
Yeah, am I audible? So thank you for this opportunity. So I work for a company called Novenesis. It is an industrial biotechnology company, right? And the key benefits of AI is basically to reduce the time, reduce the effort, and also reduce the cost, right? That's typically how AI is being positioned. So where in terms of biology or pharma, where can AI be applied? as Madam had previously shown, in the drug discovery or drug discovery development, right? It takes 10 to 15 years for a drug to be developed. And there are two parts to it. One is the preclinical stage, where there's a lot of research done on screening and developing it, animal testing. And then there is a clinical phase where you then qualify to put the drug into a human, and then from the human, then you go up to see whether it really works. So the whole phase is divided into preclinical and clinical. So in terms of AI and its impact on biopharma and biotechnology, the AI can do a lot of improvement in the preclinical stage. If you had seen the Hindu editorial today, they talk about the AlphaFold 3, right? So AlphaFold is a software that has been released by Google and Isomorph Technology, which is also a DeepMind company, right? They have figured out a way by which they can predict how the proteins and other molecules, biomolecules interact and interact to this the particular thing. So thereby, instead of doing a lot of lab experiments, you could, in principle, simulate those interactions in the laptop, and thereby you could actually reduce the cost and the time for this. So primarily, this is simplifying the early preclinical research. But how does it impact biotechnology per se, right? So a lot of these research previously was centered around huge companies that had a lot of investments in technology. A lot of preclinical research needed, a lot of screening, and a lot of manpower, and a lot of investment. But because AI is now easily available and that can replicate or that can do things without the presence of a lab, the research itself is being democratized. The early research, early stage system or early stage discovery actually is getting democratized, and so it's available for everybody to actually invent. And so big companies are finding it very difficult because what was their role in developing these drugs are no more their own intellectual property, right? That's now there's more competitors in those basic drugs. So I think companies are starting to think about how should they do their IP strategy such that they can think about having exclusivity to things that are not really part of their of the general public, right? So for example, their expression technologies or others, how can I do it, right? And also companies are trying to look at whether there are non-patent IP protections that are available, for example, trade secrets. So this is typically how the biotechnology segment is being affected by AI.
Thank you. Thank you, Dr. Harish. Right. Really been, the AI is, as Dr. Harish has said, right? So really we are going to see a lot of, the changes specifically in the pharmaceuticals and the biotech industries in coming time. With respect to a lot of, the specifically in the terms of, the forecasting and, the predictions method where, the AI going to be the more helpful. So now the next question comes to Dr. Amar. Since you are masters in, the APIs, means, the drug discovery sides, right? So what is, how do you see, the role of AI in the drug discovery program overall, when, the new molecules, just to explain you the audience, because since you are, the law backgrounds, right? So in pharma, basically we deals with, the lot of drug discovery related programs at the initial stage, right? So how do you see AI can change, this, drug discovery programs in a very, the efficient manner?
So, thanks, Dr. Vikas. First of all, when we are discussing on the today's topic of AI in pharmaceutical industry and biotech, first of all, we should know that we should first differentiate what AI and pharmaceuticals are, and what age-old studies we have come up to this level. So AI, as it name suggests, by artificial intelligence, that's the common jargon which is being used in day-to-day practices. But whether it has penetrated into the real world, whether it is a robotics or a pharmaceuticals or an automobile or any other sector, AI basically is a product from an IT, but it has now started penetrating in pharmaceuticals as well. So as the question has been asked by moderator, there are certain dynamics which are changed in past several years, and some statistics which I could research and bring for the audience. As per the survey, there are 80% of the pharmaceuticals and life science professionals currently using AI for drug discovery. Now, drug discovery as a phase, when we talk about, ma'am in the presentation on patents explained about the time frame of 10 to 15 years about drug discovery, and that is a tedious process. Like, it has 4 phases of development: phase 1, phase 2, phase 3, phase 4, where from animal trials to safety studies and to the human trials and to bringing to the product to the market. The fastest of the development what we have seen, again I would like to correlate from the madam's presentation on COVID vaccines, where the need was there, where many things were done parallel, and we could see the vaccines hitting the market at least with less than a 2-year time. But if you in normal practice, if we see a drug discovery program, it's a very vast program, and it has to be a lot elaborate. But when we talk about AI in terms of drug discovery, it is purely a data analytics. So how a data analytics, and it's a new field again, the interpretation of the data. AI basically helps in the drug discovery with the help of a data set which is available from all the different phases, and try to reduce the time of drug discovery and bringing the product to the market. So I'm not surprised by this statistics that 80% of the professionals are using today AI for the drug discovery. But I'll quickly go through some statistics which can help that how it has been helpful in the drug discovery program. 95% of the pharmaceuticals company, they have started investing in AI capabilities. I could find some collaborations which are very much known. Pfizer, very well-known company, has started collaboration and partnership with Concreto Health AI. Janssen Pharmaceuticals, arm of Johnson & Johnson, they have started in 2019 a collaboration with a French startup to develop an AI-powered drug design system. Sanofi, another big giant French multinational company headquartered in France, they have started working with an AI partnered startup to develop solutions for the drug discovery. And some of the companies like Novartis and Bayer, they are also started. Specifically Novartis, they have done their collaboration in 2019 with Microsoft for a multi-layer partnership which leverage data and artificial intelligence based on AI empowerment and AI exploration. Now, when we see this kind of collaboration, 2 different segment of companies coming together, IT altogether investing in pharmaceuticals, and pharmaceuticals taking help of IT industries to bring up a unique solution. So these are the early days of this type of collaboration, and not surprised by the early days of this kind of signed by the big giant companies who are working in this direction. Market segment is very big of AI. AI clinical trials could lead cost saving up to 70% of the trials and timeline reduction of up to 80%. The drug which could hit the market after 5 years, 6 years or 7 years can be brought to the market in 1 or 2 years, as what we see in the COVID time. But those were stringent times. Normally those times are not the drug discovery, because the failures are more and the successes are less. Not every drug entering into the drug discovery will enter to the market. So basically AI is shaping the future, but there are still a lot of to be done. So we can dwell later on those questions.
Thank you, Dr. Amar. I totally agree with the Dr. Amar thought process. So basically, in drug discovery segments in coming time, definitely we can see the impact of AI, because nowadays what happening is, previously the big giants which Dr. Amar has mentioned, right? They used to take lot of the times as well as lot of amount the monies in investing one of the drug molecules. It may be the couple of more years, 10 years. So I can see the more impact on towards the significant reduction in the time, because of the the predictions and the forecastability of the data with respect to the niche areas where there is an actual requirement of the AI in this space, right? So coming to the Mr. Amitabh, right, with respect to, so basically nowadays the big question is for pharma industry is with respect to the supply chain issues, right? So how do you see in pharma specifically, how do you see the impact of API in the supply chain area? how it is going to ease, because sometimes we see there is shortage of the raw material availability because of the certain issues where the finished suppliers could not be able to make the products, or there are other ways around where there are a lot of impact associated with the supply chain issues, right? So how the AI can ease this the issues in the pharma and biotech space?
Okay, thank you. Actually, because if you see for any technology, not for biopharma and other also, because since topic is roaming around biopharma,
Right.
first you see that what is the need. Very important point that before you are approaching any technology development, certainly after technology development, then you go for product. So what is the need? First is the need assessment. The moment if you are able to do good need assessment, then you perform technology forecasting. Technology forecasting is like that what would be the market trend after 2030. Then third point is that cost economics. Regarding your question that supply chain, because if I am able to you can perform my need in a better way, certainly I would know that what are the exact parameters and what are the, you can say that raw material, plant machinery and other issues I have to handle. Then technology forecasting. Because if I am assessing, say in the biopharma segment, that if I am able to develop after 2 or 3 years, that is with the intervention of any, you can say the modern technology, whether it is AI or you can say the machine learning or anything. So certainly through technology development, I got the product. But what happened, due to wrong assessment at initial stage also, and even after 4 or 5 years also, I may be knowing that this particular raw material is missing in the market also. Earlier I was used to get the same thing, but that is missing also. Another important that before product launch and at the start of technology development, what is the cost economics? Because whether I was able to do better cost economics of the product as well as technology or not. Because before product launch, we have to ensure that what type of technology trend is having at this moment. Because what happened, if particular technology is active today or performing good, certainly after 2 or 3 years that may not be that level also. So keeping in mind that to at least assess the goods supply chain, whether that is in technology line, whether that is product line, we have to at least perform our assessment at initial stage. Suppose if I am going to launch any product after 2030, say in 2032. So now we are at 2024. So at this stage, it's very important for me to at least good need assessment, then market need, then you can say that what sort of, you can say that keeping in mind that I can maintain particular supply chain in a better way. So that is in short, according to my view.
Thank you, Mr. Amitabh. So I've been agree with his thought process regarding this supply chain, the basic the fundamentals. I also had one more thing in this, right? So with respect to sometimes in supply chain areas there are very few limited the players availability with respect to those materials which we wanted to the outsource or which we wanted to somewhere we wanted to procure, right? So the being a AI implementation in that area, that will provide the better visibility and overall the good launch planning for the organizations in the coming time. So definitely it will ease lot of, it will reduce lot of burdens specifically for the pharma industries when they are targeting the good launches in the coming time, right? Coming to the next questions to Mr. Chirag, right, with respect, so since we discussed a lot of so with respect to what are the challenges you can see associated in this the AI area, specifically in the pharmaceutical field, right, and how we can overcome those challenges?
Yeah, thanks Vikas. First of all, thanks the Manipal Law School University to give me the opportunity to share my views on the AI and its impact on pharma field, as I am associated with pharma field since last 17 plus years. I can give some inputs, but not throughout AI, because AI is a novel aspect affecting the pharma field. And as an audience, I believe the larger audience is basically from the law school, and those may not have the scientific background, but those who actually want to pursue their career in the pharma field of IP, especially in the field of patents or trademarks related to pharma and biotech. I'm not aware whether science background students are there or not, but it may be more useful to them, because if they want to pursue their career, it may be more helpful to them. Now, what is AI? First, because before going to the limitations of AI, we need to understand what are the importance of AI and its implications in the pharma field, and how it is actually affecting the importance of drug delivery and drug discovery and all those stuff. Because it's actually implementing the algorithms, means based on the factors affecting the final outcome, the AI system, that means the computer components are generated through large set of data, so that algorithms are created, and then the AI technologies, means computer components, are trained so that they can interpret the data which are coming on the another set of data, and then that will give the proper result, like which is giving the results in very less time, and that may be related to the decision making of at certain stages of pharma and biotechs. Now, coming to the limitations of AI, because we know, like currently new technologies are coming in, and people are understanding currently, like what are the actual impacts, what are the generations, next generations are going to use the AI, how it will impact the pharma and biotechnological fields. There are certain limitations, for example, lack of transparency of the data. That means the data are largely data are fed into the system to create the AI technology or computer components, so that those can be trained together. Now, those based on those data, means the computer components will be giving the complex algorithms, which are actually difficult to understand, and that's why it may give a lack of trust if it conflicts with the clinicians or researchers in terms of their understanding of the pharma and biotech field. Then the second limitation is related to the limited data availability, because as AI is generated only based on the metadata given and fed into the system, like there are certain diseases which are orphan diseases, or the patients are very less. So in those cases, means large data cannot be fed, and without large data fed into the system, one cannot have the proper algorithm which can give you the exact precise decision over the any treatment part. So that may give some biased result based on the data available. Then third limitations I could see is the inability to incorporate new data, because once AI is fed or AI model is trained, new data cannot be inserted or incorporated into that to give the training to that model. So it is very difficult, and in this dynamic pharma or biotech field, means it is required to update the field so that AI may incorporate those new data, and that will give the proper decision based on the overall data, not only with the data which were earlier fed. Because pharma and biotech field is too dynamic, so every day means new data are coming, and I am sure, like the scientists and the researchers who are actually working on this AI system, they will think on this part. Then the next limitations might be the ethical considerations. For example, patient privacy, because the data are taken from the patients, means irrespective of their consent. Because I have doubt like how data are collected or gathered and then inserted into the AI models. But if that is the case, like privacy of the patients are not maintained, then it should be tackled with judicial justified reasons, like why those data without consent can be added or not into the AI model, just to train them to give the decision in the future aspects. So data safety and security are the main concern. Then the data ownership, like somebody has taken a data from the hospitals, for example, from the patients. So who are actually the owners, or who is having the ownership of the data? That is also not known. So I believe with this, I should stop discussing on the limitations, because there are many more things to discuss on the actual AI part affecting the pharma and biotech. Thank you so much.
Thank you, Mr. Chirag, for valuable inputs. Right, so I totally been agree. The data has a lot of impact, specifically in a pharma area, because you cannot extrapolate those data with the other field. Like in other fields, it is very easy to extrapolate the data, right? But in pharmaceutical case, it is very difficult, right? Because of the consideration what he stated, the patient to patient variability, or there are many more factors, right, which needs to be taken care. So this is going to be one of the the challenging part when the AI going to be straightforwardly implicated in the pharma area. Now coming to the next round of the questions to Dr. Haris, right? So since we are on the verge of implementation of AI in the pharma and biotech industry, so what kind of the regulations that industry should keep when implementing the AI in the organizations?
Yeah, I think Chirag actually pointed out to these dilemmas, right? So how is data privacy, right? How is data being trained? Who owns the data? Do we have access to this data? Does this? So a lot of it, I think, has been covered by Chirag. But what I would like to talk about is the impact of these AI per se in IP, right? For example, you could see that AI in patent technology itself is there for search and analysis, for drafting and others, right? So how does that impact the IP, intellectual property field itself? The second part is, how does that affect prosecution, right? Say for example, we have the typical in patent terms, the person skilled in the art, right? A person skilled in the art is the one who is responsible for the defining the the obviousness. So inventorship, right? So if technically the person skilled in the art was a person who had all access to all books, but couldn't make many of these assumptions by himself or connections by himself or herself. Now with AI and ChatGPT that can synthesize a lot of this information, the person skilled in the art definition would be a little more higher, right? So a person skilled in the art would technically be a person who has access to a large amount of information, and then a ChatGPT kind of thing to actually synthesize it and do it, right? So technically, I think in future, the level of inventorship would actually go up, right? The person skilled in the art is not the standard anymore. The patent office is going to have a higher bar on inventorship. That would lead to a lot of the challenge in how to get good patents, right? How to get strong patents, how to get broad patents. That could be one implication of how the AI comes into play. And then with AI, what you could also do is that if there is a molecule, you could invent around that molecule much more faster using an AI than traditional technologies, right? So that would also have implication on what kind of claims should you go for, right? So is your claim going to be the standard way, a sequence or not? Because then maybe you give it to an AI and the AI can find out another molecule which is outside, but then does the same work, right? So the challenge for patent attorneys is also to make sure that how can I draft it in such a way that it cannot be overcome, right? Or it also covers what an AI does. And I think that is the way fundamentally the AI is going to impact at least patent law per se, right? There's going to be a lot of information synthesis happening that can give you good insights. Drafting it would be a challenge because the FOSITA requirements go up. and then any claim that you get can be easily worked around with this one. So it's going to be an interesting challenge how the companies work around this. And also for companies to look at it from a strategy point of view. Do I need to have a regular kind of claims, or do I find claims that are not breakable by AI kind of technologies, right? I think that's the dilemma that comes up. The clinical aspects of whether this who makes a mistake or what happens if AI makes a mistake can be more or less solved, at least in the human thing, because there is no replacement for clinical trials, right? You have to give it to a human, you have to test it for side effects. So in my opinion, there's not going to be much error there, because you can have much more analysis of the data that comes out. So I think overall, it would impact drug discovery development process in a good way, but it would impact patents in a kind of a negative way, because it becomes much more difficult to get patents which are strong and broad enough for people to actually enforce and get this.
Thank you, Dr. Aris. Right. So coming to the next round of the questions to Dr. Amar, right? Since pharmaceutical industries or biotech industries has a lot of departments, right? So which departments? Let's say I would briefly describe for the audience, right? So pharma industries has the departments like R&Ds, productions, right? Then the business teams is there. Then there are the supply chain team is there. Then there are the corporate teams also, right? So which departments you see there is, which areas in pharmaceutical where there is actually the need of, the more need of the AI in comparison to the other areas who are functioning smoothly.
Okay. So thanks Dr. Vikas for putting that question. Basically when we think from a pharmaceutical company perspective, of a single drug when it comes to the market, it has gone through number of stages, and many people has given their intellect to bring that product to the market. Now when we are dealing this subject of AI, but the core theme of today's discussion is also intellectual property and rights. There are two aspects of the departments I can name down, like which will be affected or where the AI can make some disruptions, or I would say bring out some quantitative or qualitative outcomes, like QA and QC are the one, quality assurance and quality control. Pharmaceutical product management, that is a team which is consisting of market positioning, market prediction and analysis, product costing, that can also be impacted by AI. Clinical trial design and monitoring, as Dr. Harish recently mentioned about clinical trials and its impact. It can like subject enrollment, market prediction analysis and product costing. Pharmaceutical product development, that is the total life cycle of the development of a product. Pharmaceutical manufacturing, once the product is developed, how it will be manufactured. And finally the drug discovery, that is the drug design and the drug screening. Now to all the students of law and general person in this August gathering, the drug discovery altogether is a different domain. We are just trying to link this drug discovery with AI and pharmaceutical as a whole. So what does AI will do when this all departments will come into the picture? Like it is again a data set. Normally in normal context, the drug is developed probably based on a QSAR modeling, that is called qualitative structure activity relationship, where you have a library of hundreds or thousands of molecules, and you screen them for a new molecule and see that whether this molecule is already been tested. You try to tweak the molecule with some different combinations by replacing some atoms into that, and or the functional group, and you again go and synthesize that molecule and check the activity. So that's the reason this whole process takes 10 to 15 years of time to bring one molecule to the market. And then it is the target discovery for the indication or for the problem which we are developing this molecule. And when you will work with an AI, this whole departments which I mentioned have their own role to play. The basic thing which everyone has to see is that the AI will play a part of it, but the interpretation of that data cannot go wrong. Because once you bring those data on the table and you try to see that whether by a human intervention that data what we were seeing after screening those 100 molecules or 200 molecules from phase 1, phase 2, phase 3, phase 4. Remember that from a regulatory perspective or a regulatory framework, you cannot avoid this one. You cannot bypass all these phases because each and every phase has its own importance, whether it is a safety study, whether it is a human study, whether it is an animal study, stability study, pharmacokinetic study, everything has to be tested for the side effects because you cannot end up with a drug which has a very minimal effect over its counterpart and the side effects are huge. So, and even in today's world, you see the discussions recently in the last week started again on the COVID vaccine where there were many things coming and scientific team coming out and you see news debates going on that and everyone start giving because many of us has taken a vaccine, perhaps many of us has taken a COVID vaccine which is of AstraZeneca. So whether the side effects which are being discussed are being studied properly, the benefits are more and the side effects are less, machine and algorithm can bring you some data set. Again, a human intervention will be needed. So quality assurance, quality control will have a role to play. The scientific team has a role to play. When you take a set of molecules from one phase to another phase, you will drop down because you will not only work on couple of molecules, you work on thousands of molecules. So from phase 1 to phase 2, phase 2 to phase 3 to phase 4, when you go, molecules get scattered and you will end up with only 4, 5, 6 molecules which are your key candidate or a lead molecule. And then you come up with a final miracle drug which you would like to see and test in the volunteers who are having the disease and whether that is being benefited. So again, AI can give you an inference, but and it can definitely reduce the time of discovery, reduce the time of clinical trials by running an algorithm on already fed data set and can bring up a data in a very small time where after reading to that data, a human will take a longer time to bring it, make it a data. So remember one thing like data, information and insight. We are talking about insight. Generally, people see a cluster of data and try to give an answer to that. Data cannot be used to give only an answer. Data has to be first converted into an information. Information has to be converted into an insight. And then insight will try to give you what you want and take it the step further. So I think so these are the departments in a large pharmaceutical companies which will play the role. Of course, when AI will implant, I don't foresee it, my personal view, that human intervention will be neglected or nullified and you will start directly go from phase 1 to phase 4 without any interpretation of the data. Obviously, it will have its own way, but these are the departments, Doctor, which will have this own role play. Thank you.
Thank you, Dr. Amar, for a wonderful view. I absolutely agree with his view, right? There are the two major departments since he stated the drug discoveries and the clinicals, where a lot of the investments of the company happens and where there is no certainty specifically in pharma and biotech industries for results to be outcome, right? Because of the the lot of the experiments in the animals and the humans where it is very difficult to predict the data, right? So if AI can come in these areas where they can predict predict the results based on what has been gone in the past or what can be the future success, then definitely it can save the huge amount of the cost for the organization, plus at the same time it can be the beneficials for the patients as well as the populations also. Now coming to the next round of the questions to Mr. Amitabh, right? So in biotech industry, this questions relate to specifically for since one of the areas is biotech industries in the AI, right? Biotech industries involves lot of the antibodies and the immunoglobulin programs where the lot of the process related challenges are there in manufacturing specifically, right? So which areas how we can optimize this process related specifically manufacturing related challenges in this the biotech areas with use of AI, right?
Okay, thank you. Basically, if you see the processing part, if you are going to develop technology through biotech route and if you are going to technology through pharma route, it's quite different. And technology wise also, even disease wise also, there are certain steps. Because if I am going to develop any molecule that is having application in cancer and diabetes and other TB, etc., because it depends on that which type of product I am developing. Because if you see through biotech route, if I am going to develop one medicine, so there are certain steps. It's not that from step A you will reach to step Z. In my opinion, as per my experience goes, because I was involved in more than 20 biotech product development, its commercialization, and its regulatory approval also. The main important thing is that scaling up. Because since you know that I am from NRDC, so basically we used to get the technology from the laboratory. So at first you have to develop the technology at lab level. So certainly from lab level, so you can say that is TRL 3 or 4. Then you have to go for the product level, that is TRL 8 and 9. In between there are certain steps you have to follow very carefully, and the moment if you are succeeded at step 3, then certainly you will move for 4. So according to me, this scaling up is a major challenge, because I have seen that, because if I am able to develop any product or any molecule at particular stage at lab level, certainly while scaling up, going from this various stages for reaching at pilot level, there are certain failures also. Directly you may not succeed, and even by using AI, I am not sure, but there may be a possibility, because now you can say that our partners are using this also, but it is yet to be confirmed that whether that scaling up issue would be resolved or not, because that is very major challenge. And even the moment if it is resolved, certainly you have to see its success at particular capacity or not. So in short, according to me, it's scaling up the major issue that is very important in biotech sector.
Thank you, Mr. Amitabh. Right. Coming to the next round of the question to Mr. Chirag. Since just before asking the questions, I'll give you the background, so the audience who are not from the technical backgrounds of the pharmas and the biotech, right? So basically in pharmaceutical industries, there are a lot of scientists who works on the bench floor, right? They do a lot of research and they come up with certain things over a period of the times by which the more successful the product can brought into the market now. So since we are talking about the AI implementations in pharmaceuticals and biotech area, right? So AI is and at the same time we are going to reduce the human interventions also, right? So what kind of collaborative efforts required between the AI researchers as well as the pharmaceutical or biotech scientist who works on the softwares? So the smoothness or easiness in the work can be implemented. At the same time, the human interventions can also be minimized without any other. So what kind of collaborative approach as per your the fundamentals is required in this space?
Okay, thanks for the question. I think there are many models working on the AI, and just to give you the brief background, like how they are working in different kind of categories of technologies. It is in general, means it is not specifically related to pharma or biotech, but how AI is working and what kind of technologies or machines are available for taking any decision related to the any technology, not only pharma or biotech. So basically the first most part is the machine learning. Now what is machine learning? It's actually implementing algorithms and identifying patterns in data to aid the decision making. Now there are multiple ways of this machine learning, And those may include supervised learning, unsupervised learning, or reinforcement learning. That means after giving or feeding the AI system with the data, how to reinforce from that data to have the benefit on the decision making activity on any field. In that, deep learning is the main thing. Like in the machine learning, deep learning is the one important component by which layered structure algorithms are generated. In deep learning, there are multiple neural networks are associated with, and the major ones are like ANN. What is ANN? Actually, ANN is artificial neural network. Now, what is artificial neural network? It is really means beneficial to understand first like what is ANN, because there is a vast role of this ANN in different technologies in different fields, including pharma and biotech. ANN is actually a collection of intricately connected computing components that simulate the electric impulse transmission in human brain. That means if humans are involved, then human brain decodes this electrical impulse, and the similar kind of things are included in the machine, and that is why it is called as an artificial neural network. So that is called as a perceptrons. So by these perceptrons, these systems are generated, and that is actually a human intervention, because all the data needs to be fed and all relevant data needs to be fed before generating this kind of network system. So apart from this ANN, there are different other network systems are also available. For example, convolutional neural network, then recurrent neural network, then multi-layer perceptron networks. These all kind of networks are available in different kind of pharmaceutical and biotechnological fields for decision making of various technologies. So especially in the field of pharmaceuticals, as I am a pharmaceutical formulator, there are various impact of AI on various drug delivery systems. For example, tablets or capsules in a layman language. If you are taking a pill, and then in generation of the pill, like what kind of impact an AI can make. So for example, there are multiple conventional dosage forms like tablets, capsules, granules, and there are multiple other dosage forms. For example, matrix driven modify release technology, control release technology, nano emulsion, etc. So by using this ANN technology or machine learning technology, we may actually use this AI technology to have the understanding of drug release from the dosage form. Means tablet, if you presume something like what kind of drug delivery will be happening from that particular dosage form, it will be really easy for understanding like how that tablet will be useful and what kind of body parts will be affecting by taking that tablet. So this is just an example, means there are multiple ways of using the AI technologies in pharma and biotechnological field. Thank you.
Thank you, Mr. Chirag. So coming to the last round of the questions, I would request panel member to answer in just 2 or 3 minutes since we are running short of time, right? So to coming to the Dr. Harish, right? So how do you see the AI, the implications over the next 10 years or 5 years of the times, in specifically in pharma and biotech areas?
Yeah. So as I said, AI will fasten drug discovery, reduce cost, and also reduce manual errors. I think that's a given, right? Sir Amitabh sir was actually talking about scaling up. I think if the company actually collects a lot of data during scaling up with sensors, I think it can quickly do it, right? We can see lots of companies actually being able to manufacturability for their molecules at a much faster pace than normal. So that is a big impact that you can see. Maybe drugs will be much more easier, less side effects, faster to the market, and probably less cost. But as I said, the implications for IP professionals per se would also change, being able to understand AI along with the patent landscape, who owns, who's an inventor. Those are the kinds of dilemma that would be increased in the near future, and many court cases or laws would actually clarify many of these positions as to how to treat inventions by AI. And I think that would also, you could see the...
Thank you, Dr. Rish. I just wanted to add one more point in this regards, right? As you already stated, so with respect to the clinicals and those part where there are major challenges, right? So where we can see the lot of implications in coming time, because that's burdensome for the industries, pharmaceuticals or biotech industries, where there is actually the huge requirements for these implications of the AI in the coming time, right? Coming to the next round of the questions to Dr. Amar, right? Specifically in IP, in pharma and biotech industries, right? What kind of impact we can see for the AI in coming time, and how it is going to easy the IP related work in those, the routine day-to-day in pharma and biotech industry?
So basically, when we say IP, we are much talking about the patents and the trademarks and the copyright. But as far as the pharmaceuticals and biotechs are concerned, we are more concerning ourselves to the patents first, because trademarks will come at a later stage when you have a brand which is already built up. So when I take this question and to answer in a very nutshell, the patent searching tools are now coming with the help of an AI-driven searching database or AI-driven interface, but it is keyword-driven. Again, what you think and what you get is not the way. The recent tools what are the available from the market are structure-based searching, author-based searching. We can combine the cache number of the product, which is a chemical abstract service universally. Every molecule has a unique cache number. So all those searches are being done. You get your full data set, and then you list down the patents and the innovations or the protections by the companies across the world again around that molecule, whether it is a product patent, whether it is a process patent, whether it's a pharmaceutical composition patent or a polymorph patent or a method of use patent. All those things are covered when we have a final cluster set, so that when we go into the market, we don't want to see any patent which is missed from the study perspective, and we don't get a surprise when we launch a molecule and we get sued on a patents which are not been reviewed earlier. Now with coming in the AI, it says that it will reduce your time for screening the patents and bringing them to your table very fast. But there is also a catch in this. The keyword driven or the data driven analysis sometimes may happen that you may find that some patents are missing, because the algorithm which you have feed or the used of that algorithm sometimes will not give you the exact data set. So only relying on the AI enabled searches, considering that it is foolproof and everything has been covered, will be with myth. It is still in a developing phase. I would say that still there are platforms which are coming. They are also experimenting. They are also trying to build a algorithm, robust algorithm, where you feel that there is nothing which will be missed out. But as you go and progress on a pharmaceutical base, it is not only the structure, because when the molecule is discovered, no one knows the structure. It is at a very later stage when the final structure comes. It is still a later stage when you know the name of the molecule, and it is still at a later stage, but you start filing patents around that molecule very early stage. So to miss a patent, it will be difficult. So my takeaway will be like, it is in a niche stage. We should be using this with a pinch of salt, and not only rely on the search engines which are AI driven.
Thank you, Dr. Amar. Wonderful view. So coming to the next round of the questions to Mr. Amitabh, right? Since I just want, can you please describe, okay, what kind of the best practices companies should implement, when they are on the initial stage of the AI implementations, right? Because where there are a lot of uncertainties, because it is on the initial stage or the very niche stage of the AI implementation. So what kind of SOPs or the best practices companies should implement?
Because regarding SOP, that is to be followed at company level or at lab level also. Here I would like to just share, although it's my personal view, that there are two areas. Because at laboratory level, where AI is being first used. So for designing a SOP, certainly you have to see that what sort of infrastructure you are having and which type of expertise you are having, and whether that expertise is complementing to the available infrastructure or not. Coming to the biopharma companies, certainly they have a good infrastructure and they have a excellent manpower to complement that infrastructure also. As far as SOPs is considered, because suppose if I am running one biotech company, certainly I am not developing each and every technology, right from diabetes to hypertension, cancer, and other, etc. So we have to first prioritize my area of development. Then accordingly, you have to just see that what type of SOP you are going to implement in your organization. Because it's depend. Because based on same SOP, you can't develop any molecule. So as far as SOP is considered, you have to see that as per your available infrastructure and manpower, that you see that based on that SOP, you are able to develop that technology that cover all aspects, such as good data for preclinical study also, because based on that data, you may approach DCI, etc. also. And after getting the approval, certainly you will move for further clinical trial also. So according to me, for this developing a good SOP, there are certain steps, and that step must strengthen, you can say, your product development to start with, you can say, preclinical study and to end with the last, you can say, phase 5, phase 6 clinical trials. Thank you.
Thank you, Mr. Amitabh. All right. So I certainly agree with his thoughts. There are certain, the best SOPs, whenever the industry is planning to keep, they have to implement, because there is no surety in the pharmaceuticals, right? How it will go and what kind of, the results it will perform, whether it will align with, those, actually working with, the pharmaceutical scientist results or not. Now coming to the last questions to the Mr. Chirag. So what will be the future of AI in the pharma industries, right? This is just, very...
Yeah, thanks. As we discussed, like what are the implications of AI on major departments of pharmaceuticals and biotech fields. The future of AI, because it's just like a baby right now, and there will be growth of this baby in near future or very soon, and that will have major impacts on all the fields, including pharmaceuticals and biotechnologicals. So to put in a very short brief, like that will help to accelerate the drug discovery and drug development, so that newer compounds without much delays can be entered into the system for different level of therapeutic categories, including cancers and AIDS and other diseases which are very crucial and which are impacting many patients in the world. So I think to take a positive note on that, like AI will have a positive things like the newer discovered drugs, early entry in the market, and will be patients will be benefited for sure. Thank you.
Thank you, thank you. So with this, I just wanted to add a couple of more viewpoints from my sides, right? With respect to the AIs in pharma and biotech, right? It's very, it's not easy, as already panel member discussed, to implement AI in the pharmaceuticals and the biotech industries, considering the lot of, the human resources, considering the lot of, the clinicals and, the experimental data, which is sometimes, easy to predict, by the AI, sometimes it is not. If it is not easy, then, someone has to be validated. Like it's not like that, some other fields like IT or electronics where we are discussing, where, all aspects works on the algorithms, right? Sometimes here, since we deal with, the human lives, it's very difficult to apply, in all the areas. But once over a period of time, definitely technology is changing. Over a period of time, if the AI is going to be implemented, then definitely we can see the rapid and the fast growth of the pharma and biotech industries, right? Whatever the pace rates, currently the pharma industry is going, we will see the number of, the more fastest growth of the pharma industry, right? So with this note, I would, thank you all the panel members for their, the wonderful and the fruitful views on this, and I wish you a good luck. Thank you.
Thank you so much for the speakers and the moderators especially for bringing out the nuances with regard, the practical aspects regarding the domain of pharma and the biotech and its implications. Now it's time to felicitate our speakers and also the moderator. I call upon, I request Professor Venkat, please sir, I request you to do the honors. I'll call out the names. Dr. Amar Rajendra Desai, please sir, this way, this way. Thank you so much, sir, for the efforts and the time put in. Dr. Harish Chandran, please sir, you remain there, sir. Thank you so much. Mr. Chirag Soni. Mr. Amitabh Mishra. Thank you so much, Professor Venkat, and thank you so much, sir. Dr. Saha. Yes, Dr. Saha is here. Dr. Saha, I invite you to felicitate and do the honors to our moderator for the session. Dr. Vikas Agrawal. Thank you so much, sir. Yes. May I request all the speakers and the panelists and the moderator to come forward and have a photo session of this moment. May I request Professor Venkat and Dr. Ali to join? Dr. Ms. Revati? Anybody else? Ali, that's it. Come soon. Kiran is not with us. She left. Okay. Thank you so much. And now this is the lunch time. And after the lunch, we will be having 2 parallel sessions. One parallel session will be happening at MLS, Manipal Law School building. And the third panel session will be happening here in the same hall. So panel 2, Dr. Rajinder Kumar Sapru, Mr. Amitabh Mishra, Mr. Prakalpa Sharma, Mr. Rahul Dubey, and Professor Dr. Pinaki Ghosh will be having the session, the panel discussion at the Manipal Law School building. A room. You will be guided towards Manipal Law School once the lunch is over. 2, right? By 3. Okay, what time limit for the lunch? Allahabad, PhD in Public Policy and Big Data from George Mason University. His specialities include Linux, distributed systems, DevOps, cloud, networking, big data, AI, ML, Internet of Things, public policy, and open source. May I invite Dr. Sachin Garg onto stage? It's my pleasure to invite Mr. Balwant Rawat, Head IPR, Mercedes-Benz, R&D India. Sir is having a BTech in Computer Engineering from Banaras Hindu University, and he is a postgraduate diploma holder in Management for Executives, IIM Indore. He is a registered Indian patent agent. He leads the IP and strategic intelligence activities for Mercedes-Benz Research and Development India, MBRDI. Before joining MBRDI, he was the head of IP Center of Excellence team at Eaton India Engineering Center and senior manager of the IP operations team at Evalserv. Committed to inventor rights, he advocates for the recognition and remuneration of innovators, reflected in his published research on the need for inventor remuneration law in India. He is also an executive member of India IP Alliance, a non-profit entity committed to bringing together various IP ecosystem partners, that is the creators, protectors, and enablers for the greater good of society. He is recognized as one of the world's leading IP strategists by IAM Media and a recipient of the IP Excellence Award by ASSOCHAM and the In-House Counsel Award by India Business Law Journal. He is also a certified innovation coach in design thinking, a certified lean and agile practitioner, a registered patent agent with the Indian Patent Office. I invite you, sir, onto the stage. It's our pleasure to have you here. Now may I invite Mr. Sujit Subramanian, General Manager, IP and Innovation, Samsung India. Sir is having BTech in Mechanical Engineering from NIT Tiruchirappalli, registered patent agent with the Indian Patent Office, design thinking for innovation certification from the University of Virginia. He has a passion for developing and protecting innovative solutions that enhance the user experience and create value for the company and the society. Sir works with a talented team of researchers, engineers, lawyers to foster a culture of innovation and collaboration across Samsung R&D Bengaluru. As the General Manager of IP and Innovation at Samsung Electronics, he oversees the creation and management of the intellectual property in AI, Internet of Things, and multimedia technologies. Sir, I invite you to take your chair, be positioned on the stage. It's our pleasure. We have Mr. Siddharth Karkanis, Head IPR, Robert Bosch India. Sir is having BE in Electronics, LLM in Intellectual and Competition Law from Munich Intellectual Property Law Center. Over 15 years of experience in the field of intellectual property, which includes law firms and a corporate. He is one of the founder members of the IP practice area of Bosch India. He established patent counseling team for Bosch India inventions. Working as lead patent counsel for Bosch India for multiple business units, his duties include handling patent strategy, patent infringement opinions, IP audits, scanning of projects for IP protection, idea generation and workshops, innovation management, etc. He has extensive experience related to intellectual property in automotive industry, connected cars, home automation, home appliances, Internet of Things, software patents, hardware, AI, ML, semiconductors, blockchain, healthcare devices, etc. Sir has worked in Europe under European patent attorneys in drafting and prosecution of European patent applications. Sir, it's our privilege to have you here. Please be positioned on your chair on the dais. Now we have Mr. Sumantra Mukherjee, partner KPMG. Sir is a chartered accountant, certified internal auditor accredited from the Institute of Internal Auditors, INC Florida. He is the conceptualizer and founder of the Innovation and Intellectual Property Advisory Services in KPMG India and is currently leading the practice. Sir has been recognized by IAM Strategy 300 as a top intellectual property strategist in 2017 and 2018. Sir has served Mark Lyons leading multiple engagements pertaining to end-to-end patent technology monetization, technology scouting and acquisition, building intellectual property strategies for organizations, intellectual property evaluations, due diligence at the time of merger and acquisitions, designing and setting up risk governance processes, intellectual asset management, royalty, license audits and IP data analytics, and dashboards and open source software compliance. Mr. Sumantra is a member of the National IPR Committee at FICCI. He also acts as the COO, Chief Operating Officer of Forensic Business with KPMG for the last 2 years. In this role, he is responsible for ensuring operational efficiency of the business verticals within forensic. Sir, I invite you onto the stage. It's our pleasure to have you here.
Thank you so much.
Our next panelist will be Mr. Ravi Shankar Ganeshan, Senior Vice President and Co-founder, ITTIAM Systems Private Limited. Sir is Bachelor in Engineering in Electronics and Communication from Indian Institute of Science, Bengaluru, Master in Business Laws from NLSIU, Bengaluru, and Sir has served as General Manager in Texas Instruments for 14 years. Sir, we invite you to please take over your position on the dais. And last but not the least, we have our own Dr. Indranil Saha, Associate Professor, Manipal Law School, as a moderator for this session. I invite you, Dr. Saha. So let me have the privilege to introduce you as well to our students and the panelists. Dr. Saha has his MSc in Physics from Presidency College, Kolkata, PhD from Department of Physics, Indian Institute of Science, Bengaluru, TRIL Fellow with UNESCO and worked on cancer research in Italy, LLB with honors in IP from IIT Kharagpur and LLM in Corporate and Commercial Law. He is a registered Indian patent agent. And Dr. Saha has 12 research publications to his credit in peer-reviewed international journals and 11 field patents, and he has granted patent as an inventor in the last 2 years. Dr. Saha has been the invited speaker in the domain of IPR and technology transfer in several universities and IITs in India, and has worked in Tier 1 firms like Luthra and Luthra in the IPR team. Expertise include intellectual property rights, innovation, technology transfer, entrepreneurship, commercial contracts, IPR licensing, cyber laws and data privacy, litigation, fintech, artificial intelligence, structural biology, and bioinformatics and cancer research. I invite Dr. Saha to take your seat on the dais, and it's going to be a vibrant discussion. So let's have the full support and the full cooperation from the dais and also from the audience. Over to you, the moderator, Dr. Saha.
Okay, so students, as you might have understood by now, this is not the typical panel that you generally see in any kind of conference or symposium. We all thought that since the lot of guests here are students, and these are budding young minds, okay, who are in the early years of their graduation, and they have a lot of queries, and those queries are actually not, met with the kind of education that is provided in academic books. So you require a set of panelists, or you require a, answer bank. And most of the people use many online websites as answer bank. The problem of using an online website, especially when you're a lawyer, you must understand this. Okay, if you are being asked to give a credible information about any kind of fact, first you must know that the credible information that you should give should and can qualify as an evidence in court of law. This I would not be telling if I were in an engineering institute, but since you are lawyers, whenever anybody asks you to give a document as a proof, you must ensure that that document can serve or does qualify as an evidence under the Indian Evidence Act as a proof in court of law. Okay, so many of these students have not only students, many of the youngsters as well as people now have this ability and tendency to just find something from the internet and then keep on arguing that I saw this in this website, I saw this in that website. Nobody questions the validity of that website. So we decided, let's go off the website, let's have people where you can have direct interaction with huge storage bank of knowledge. And these are the people where all those website people come and ask what we should write. Okay, so let's get rid of this online stuff, and I present before you an esteemed panel of people in India who have expertise in various fields, and they are united by technology and law. So they are here to answer the questions your budding minds have regarding IP, regarding policy, regarding the kind of courses that you should be doing, how you should be shaping up your future. If you want to become a corporate lawyer, you want to become a tax lawyer, you want to understand technology but you are from non-technological background, yet you want to work in IP team, you want to understand how AI works. If you are not an engineer, yet as a lawyer you want to work in the field of AI, how can you get in? Because companies might be asking BTech in computer engineering plus law. How to overcome that? These are technical challenges, practical challenges. So this panel is open to answer all your budding questions. So who has the first question? Any question relating to AI, relating to policies? Sumantra will help me out. Yeah.
Actually, before they ask a question, I wanted to ask that one question. If we have mics here with the audience as well? I saw there were many mics earlier. So what I wanted to understand first was that, is there a special affinity towards the right side of the room, that I see almost 90% of you are sitting on that side of the room? So any answer on that?
हो सकता है sir, you never
There has
know.
to be something, some logic, right?
There is a preference. Huh.
Possible. But I wanted to hear from them. I know it's a session after lunch and probably, okay, one hand has gone up at least.
What's better this side?
Light.
Lighting is better. It's more dim.
No, but thank you so much and over to you.
Huh. So if each one of you, I would kindly request, please.
There was one more.
Gain ज़्यादा है.
So since you were standing right here, I think most of us just came and sat.
But most of you were sitting on that side only. I just pulled you forward. That's it. That's all, after a lot of resistance and reluctance, especially from her.
Okay.
No, but please feel free to ask questions for us.
Where is my mobile? No, it's okay. It's okay. It's okay. Got it. I have it here. Yeah. So basically, let's start off with basic AI. Basic IP. हाँ IP का नहीं पता होगा. Okay, so मैं उठ के थोड़ा चल के बता देता हूँ. Okay, so the panel here actually first wants to understand whether at all you people are aware of the concept of intellectual property rights. How many of you are aware? Awareness is different thing than knowing. I am asking, is there awareness that what is IP? So how many people are aware? Raise your hand. There is no shame. You cannot know everything on earth, right? So 1, 2, 3, 4. Okay. So you know the word called IP, right? Now, are you aware of the fact that intellectual property, what is intellectual property and how it differs from a physical property? Are you aware of the concept of intellectual property and how it differs from a physical property like a car, a bike, a home? Are you aware? How many people are aware? So any one of you, please tell us as to how you understand, what is your notion of understanding of what is intellectual property. You can be wrong, there is no problem. Please say, please say.
Just go ahead. Just go ahead.
Go ahead, just go ahead, we can hear. Because you are supposed to be lawyers and in court You are supposed to have a voice which can reach you there without a mic. Yeah.
Good afternoon, sir, and good afternoon, respected panel. I am Krishna Kaushik from BBLLB, and as per my knowledge, physical property is owned by a person or a group of persons for their personal consumption and use as they may want. But intellectual property, on the other hand, is the subject or an object created by a person, which the person has to hold the intangible value of it for the creation, which can be used and circulated across economies. Any product which is invented by a person, the credit of inventing it is owned by the person, but the consumption can be done by anyone in the economy who has access to it.
Okay, thank you for your answer. More or less everybody agrees with his answer. So now let us understand from this esteemed panel what is intellectual property. Then comes the question of what are your rights under this property. So anybody, sir. एक पेटेंट को लेके बोलो, एक कॉपीराइट को लेके, एक ट्रेडमार्क को लेके, अलग-अलग सभी बोल दो.
See, it's interesting that you mentioned this point, but we all know that you can own a car, you can own a thing, but how's the idea that you can own an idea? The idea of owning an idea is actually, as I have researched, is fairly new. It's around 500, 600 years old and largely a product of the European Enlightenment. Did I say something wrong?
500, 600 years old and you are saying new, so we
it's new in that because, see, we are at least 2,000, we are 5,000 years old people, so the idea that something can be owned and it is something that has come out because of the, I would say, the invention of the printing press.
Printing press.
Which allowed for easy transmittal of things.
Correct.
Earlier on, there was Martin Luther who said that freely I have received and freely I am giving away. And this was Martin Luther, who was a Protestant in the 16th century. So the concept of ownership of ideas is basically John Locke 1690 writes that people have person in themselves and they will own stuff. But then there's the idea that an idea does not belong to a person because the idea is created by the society around him, which is the social utilitarianism concept by French philosopher Condorcet. And that is where the IPR basically comes in. That we create some knowledge and we have to give it to people, we have to give it to the society at large. But while giving it, we also need to ensure that there is some amount of incentivization for the creator, which comes in the form of intellectual properties. So, and the idea of freely giving away knowledge and all is also something that was been there in ancient to medieval India. The society there was, if you really look at people who have written books like Dharampal's Speaking Tree, where he has done an analysis of all the schools and colleges in India, and he basically found out that villagers used to have schools that could teach. And one concept that one could tie in, though I am not very much, because the recent is the mean Eklavya's story could be considered as an IPR thing, though recent concept by Ami Ganatra of Mahabharat Unraveled says that it was actually more of a contractual obligation rather than an intellectual property one. So that's what I want to just say, that the IPR is essentially the primary, though I would say that IPR is multiple things. Trade secret, for example, is considered IPR, but its aim is to ensure that your secret remains with you, while the aim of copyright and patents is to ensure that at one point of ultimately the knowledge will be shared with the world.
Okay, so I want to keep it very simple. Looking from technology, right? Everybody is now using technology, right? If you are using a mobile phone, right, or owning a watch, many of them would be smart watches. So you will see that technology is changing and influencing everything, right? So just think that any new feature that you find in your next phone, your new watch, any new gadget that you will see, somebody would have imagined that yes, there is a need for that feature, right? Or that's the problem statement that somebody would have thought. Now, who's that first person to realize that there is a problem or there is an opportunity, and to convert that problem to a useful feature? There will be countless inventions that would have generated. So just think that any new feature that you find in your next phone, your new watch, any new gadget that you will see, somebody would have imagined that there is a need for that feature, right? Or that's the problem statement that somebody would have thought. Now, who's that first person to realize that there is a problem or there is an opportunity, and to convert that problem to a useful feature? There will be countless inventions that would have generated. And for protection of those innovations or those inventions once before they are launched in the market itself, that is where we are talking about a patent part. So to give a personal example, so when I started my career way back in 2001, at that point of time, mobile phones were very new to the industry, right, India. It was a privilege and a luxury item, and that was a Nokia phone, right, yeah, 3200 or something, right? Some of you might have heard about that.
16 rupees outgoing call per minute.
Yes.
was also charged.
Incoming was 8 rupees.
Incoming was 8.
So I didn't have a mobile phone because in the first job, I got the phone, but then it was a very basic version. And at that point of time, the patent application that I was assigned, it was for a company called Ericsson, right?
Yes.
And once I looked at that patent, I was amazed that, this mobile phone can in future play videos through a technology which is through a standard which we call 3GPP generation, right? So that is a standards body that was getting a lot of patents. And then I realized there are thousands of patents that are actually filed, and one of them which I was drafting related to how do we send a video from one mobile device to another mobile device. Totally unimaginable at that point of time.
At that point of time, yes.
So think that, somebody really thought about an idea that yes, in future, 10 years down the line, there will be a common thing, and now everybody is sharing those videos over WhatsApp. But those technologies which made it possible, now we have gone to 5G, of course. So see how you are able to get those patents, and then the impact of those patents, let's say the Ericsson that would have a lot of patents, Nokia has that, Samsung has that. A lot of these patents are contributing and making that technology accessible to everybody, right? Everybody is getting benefited and all that. But how it is there? Because there is a protection of IP, and then the companies which have made massive investment, a lot of efforts, everything, they are also getting benefited because then it's a sharing of revenues. So all that is possible because of patents. So it's a big contribution, and it is a promotion, and I would say that overall societal development that is happening in the technology space, intellectual property has a huge role of collaborative research and everybody getting to know. So you get protection for limited time after sharing your knowledge so that others can actually continuously improve on that. So see, that's how the technological progress for which intellectual property are playing a huge role.
Good afternoon, everyone. Just to remind, my name is Sujit, and I think I'll carry on the discussion and then kind of continue. Dr. Sachin spoke about history of IP, what is the meaning of owning an idea, and how that's relatively a new idea itself. And Balwan spoke about feature, protecting a feature, and how there is an evolution in technology, how patent drives it, how patents drive evolution of technology, and how that helps the society as an overall. Now I work for Samsung R&D Bangalore. How many of you use smartphones? Yeah, see, all the hands go up. I won't ask the brand. Yeah. So when we say feature being protected as a patent, or when we hear the word patent itself, the usual thing is that, oh, what can be patented? In the morning we had a session where we said, okay, novelty, inventive stuff, or non-obviousness, and utility. That means it should be useful to the industry. These were the basic criteria, but still there is generally a perception that patenting is something that's not possible very easily, or there is a barrier with respect to getting a patent. There's something that has to be overcome. True, but at the same time, even the smartphone that you use, one of the most basic feature, we started off the session saying that please put your phone in silent mode. One of the main thing about silent mode is that it vibrates, right? It vibrates in your pocket. It's a very simple technology. I think Motorola filed a patent for that, for pagers. It was a simple concept. If you have to achieve vibration on a small scale, usually what people used to do was they used to use piezoelectric crystals. Which means you apply some current, the crystal vibrates. But crystals, as you know, are very fragile. You can't put in a mobile, or you can't put such an expensive thing inside. So the innovation is very simple. One engineer came up with the idea, I'll put an unbalanced motor inside the phone. Unbalanced motor means what? Unbalanced motor is actually a problem in automobiles. Right? You send your car for wheel balancing, paying a lot of money. But in case of phones, unbalanced motor is a solution because it vibrates. The vibration became useful for a device. The utility of that vibration, how you place the whole thing inside the phone, that became an innovation, that became a feature and went into a pager. It got used for the complete 20 years. Meaning a patent is valid, a patent, you can enforce a patent for 20 years. Complete 20 years it was enforced. So such impactful features, simple features, which someone might have seen for very long, it got a patent and it was used. So not just with, now you talk about vibration of a phone, now you're talking about AI, generative AI. We've gone to a completely different level altogether. Evolution of technology is driven by patents, but patents can also be a way to study evolution of technology, other way around also. So if you develop the skill to read a patent, skill is nothing much, just a document, but still, if you develop the skill to read a patent, large number of patents, analyze a large number of patents, such analysis can be used. You can use AI for analyzing it, you can use humans itself to analyze it, doesn't matter, but that analysis can be helpful for understanding evolution of technology. You can understand where the technology is progressing. So those are all other aspects of IP, protection. We spoke about IP, protection, and then evolution of technology, how that can be analyzed. So I'll end with that. Yeah, thank you.
Yeah, maybe what I will continue with is is not patents, and maybe that is also interesting to all of you guys, because I will touch upon more related to branding or the trademark practice, and then try to tie that into all the technology discussion. Of course, as students of law, I think one of the questions that I think is also on the Mentimeter is, how as a student of law who does not have a background in technology be a part of an IP practice. And I think the straight, very quick answer is trademarks. Trademarks protect brands, and of course, I think out of all the people who are sitting here and all the organizations that we represent, we've had several trademarks over long periods of time, and that is where you as lawyers, I don't know if you already know, if you have a law degree, you don't need to give the trademark agent's exam. You are a trademark agent just by putting a form in. So this also means that you actively get to be a part of a technology discussion, and you are also able to contribute in terms of trademarks. Of course, the strategy for trademarks is a little different than what it may be for patents, but mind you that many times trying to have trademarks or maintain trademarks is actually more expensive than patents sometimes. So this is how I feel that that you would be able to also contribute more. I think I also take one point from what Sujit mentioned was about analyzing data, and it's also sometimes about interest. And the specific example that I would give you, and if you want to contact this colleague of mine, I'll be more than happy to connect. So this is a colleague of mine who, of course, is an engineer first, but he's done his law from IIT Kharagpur. But now he is also our software developer. He has developed legal software for legal analysis. Yeah. So it is also a part of how interested you are in technology. Just because you don't have any flavor of technology before does not mean that you cannot develop anything new. I think I'll stop at that and then hand it over to Suman.
Thank you. So I'll go back before Sachin, ideally, to say that how do you protect your intellectual wealth is through different forms of IP rights. For protecting your physical rights, say for example, if you buy a plot of land or a house, right, there is a title deed which is there, which proves your right or ownership to that particular, say, plot of land or a car, right? So we are hoarders, right? As individuals, as humans, we are hoarders, right? So we want to claim ownership to whatever we have or own, right, assets. But something that you create out of in thin air, which is your intellectual wealth, your thought, your thinking, how do you protect that? How do you establish that this is something that I have built and thereby I have a right to monetize it or effectively utilize it for my benefit first before others can start copying and using it. So that's where the intellectual property rights come in. Now within that also, if you see, there are various kinds of rights, right? So for example, we were talking about patents, we are talking about copyright, we are talking about trademark, we are talking about trade secret, we are talking about designs. Now, tell me something, and I want an answer from you here, that when would you patent something versus when would you keep something as a trade secret?
Maybe I'll just explain them with an example. See, examples of trade secret is there in front of your eyes. I think most of you are feeding on that. Say Maggi masala. Does anyone know the composition of Maggi masala? Does anyone know the composition of Coca-Cola? Do you know the composition of Lay's that makes it so crunchy and so tasty? The companies never thought, however, a composition can be patented under the Patent Act. But the companies choose not to patent their composition and keep it a trade secret.
But why?
Why? Because the panel is telling you, if I have a patent, the government is telling you, we are giving you 20 years of legal protection. Nobody can touch your invention. So you can prevent somebody, and patent right is a negative right in the legal sense, which means suppose I have a patent granted for a biological molecule, that does not automatically give me the right to go into a manufacturing firm and produce medicine. No. It is a negative right in the sense it allows me to do only 3-4 things. First, I can prevent anybody from importing my invention, which is based in the form of a product or a process from outside India into India. I can prevent anybody from copying, stealing, okay, or without my knowledge manufacturing that thing into India if it is a product, and if it is a process, I can forbid anybody to use that process. These are the 3 things basically I can do. So I am in an advantageous position legally, that too for 20 years, and government is giving me guarantee. But still, as a company, I am not going for patent. I am saying no, I will keep it as trade secret, I will run in market. Why? Why do you think this is happening?
Basically, in what situation you will choose a patent versus a trade? Yeah, please go ahead.
Sir?
Correct. Very nicely put. Very nicely put. Yes, a warm round of applause for her. So, that's where these different kinds of intellectual property rights have been built into the system, that where, and the advantage, see, for a trade secret is that it is not limited to the 20-year period. You can have it for lifelong if you are able to keep that as a trade secret. Like for example, the Coca-Cola recipe, the Maggi masala recipe. I can make something which is similar to Maggi, but at least I have not tasted anything which tastes exactly like Maggi.
Yes.
So that's where you have these different rights which have to be used in conjunction to form a strategy to be able to protect whatever asset that you are owning in your personal capacity as well as in your corporate capacity. Okay, so that's a quick example about what IP rights are. What do you say?
Okay. Good afternoon. I think everybody talked about things on the IP. Let me touch a little bit upon a technology for lawyers. Okay, because one of the things that we are talking about is AI, right? I don't know how many of you, I mean, all being very young, I don't know how many of you think saying that it's the chat GPT which is actually AI. Okay. Or probably Google came up with AI. Most of the people here probably wouldn't know that it's actually a technology which is close to around 70 years old. Okay. It's a technology that started almost way back in 1950s. The technology started with a person by name called Alan Turing. Okay. And there were people. So there are things that might be interesting to understand this. It's just, there were a lot of people very early who started working on actually coming out with AI and what's called as a neural network. Okay. The neural network at that point of time was actually not that easy to implement because there were issues of compute and storage. Okay. You need to connect technology. So AI by itself didn't become like this successful in the last 10 years, I would probably say, or 20 years that you kind of like need to connect. Or it will become successful only when a lot of other technologies that come kind of together. So one of the things that is very interesting to kind of like for you people to see is, if you see Wiki, you can actually understand. Way back in 1960s or 70s, you might laugh, but 1 terabyte of memory, okay, used to be around $1 trillion. Okay. Most of you people today probably have 1 or 2 terabytes of hard disk just sitting with you. It's like $100 today. Right. So the concept actually became, so the point that I just kind of like emphasizing is, and then you're probably seeing a lot of us talking about is, this technology is becoming extremely pervasive, right? It's like it's becoming, so there are core technologies that are being developed and AI being applied. AI is what is called as a horizontal technology. So it gets applied almost on anything that you talk about today, right? So one point I just want to kind of like truly advise is, you guys want to be the future lawyers, and if you want to be kind of like associated in the technology space and the other things that we are talking about, you need to have really a good feel on what AI is, what kind of fundamentals. So if I just today just go to an Instagram and start viewing, right, you probably will see that the Instagram will actually give you next time what you have seen something similar before, right? Or the YouTubes, right? So the system is actually kind of understanding, and there is enormous opportunity in the last, what has happened in the last, I would say probably 50 years, and moving forward, things will happen a lot more faster in terms of the kind of IP protection that you can do around AI.
Okay, so yeah, keep the mic, I have this. So I hope now you people have got a fair idea about what is intellectual property and the differentiation among different branches of the intellectual property that we have, which is very unique for a single term word called intellectual property, because I think in law this is one of the branches where itself has so many roots that root itself is like 1 mile long. So each pillar of intellectual property is a big ocean subject in itself actually, which is not the subject with other laws. Okay, so this is why IPR has many facets to it, and many of these IPR wings are also connected to each other. Okay, so like we have, just for the panelists to understand, we have a Srishti School of Design here. They specialize in design. So I tell you what is design. The chair that you are sitting in, okay, is a design. The mobile phone that I have in my hand, the technology inside my mobile phone is patentable. It is a scientific invention. How the structure, outer structure of my mobile phone will look like, whether it is rectangular, whether it is square, whether it is diamond shape, is the design. Okay, table or a lock and key is a patent. How that shape of the lock will look like is a design, provided there is a catch here. If the shape of that object is also very crucial for working of the invention, then it becomes a patent. I'll give you an example. Sir, other people I would also request. shape of the wings of an aircraft. Unless the aircraft has a specific wing shape, it can never take off, however powerful engine it might have. So there the design is also a part of the inventive step, and the design can now be patented also. So are there any examples which the panel would like to see where there is overlap of IPs, where you can have more than one IPs?
So one example, for example, is the round button on the Apple iPhone, which of course we don't have now. That was designed, patented by Apple, and that's why you would see no other phone or device could have that round button in the middle lower portion ever.
So there's another example. I just remembered. So most credit cards that you have, Visa and Master, have a 3-digit CVV on the back, right? Right? But American Express doesn't have that. Has anyone ever noticed that? Amex has a 4-digit number on the front. So this is the idea of, I think it was a patent that somebody took. Either Amex took it, for the other guys took it on the back.
Yes.
And there's another story that I hear about concerns Yahoo and Google. So Google becomes big, but Yahoo was there before, and Yahoo and Google, I hope you guys know how Google makes its money. How?
Through ads.
Ads, right?
Through ads.
It shows ads, and one of the big ads that it shows is the search engine, the ads that you see on the search page. If you clicked on those ads, Google gets some money. So the idea of having ads with clicking and making money was actually a Yahoo idea. But the real challenge is, how do you place the ad on the page so that you get maximum revenue? And Yahoo came up with the idea that the ads at the top are the ones that are most likely to be clicked. So if you show the search result at the top, there is a higher chance of you getting that money, people clicking in and you getting money. And they went and patented this idea, that we will show the most revenue generating ad at the top. And now when Google comes in, they realize that they can't do that. They cannot keep the most revenue generating idea ad at the top. If they do it, they will be fall foul of the patent. So they did an economic modeling. They did the expected value. If this ad is clicked, it will give me so many. See, each ad keyword is bid for a particular amount of money. Whenever they buy ads, they buy those ads by bidding on certain keywords and saying that we will pay you that much. So what Google did in the algorithm was, they said that these are the people who are willing to buy that space, and did mathematical calculations of what's the probability of an ad being clicked. They calculated how much we are going to earn, and the one that gave them the best was the one that was put on the top. So they basically broke Yahoo's patent, found a way around it, and actually improved their performance. So one way of thinking is that a patent also helps possibly find a better solution to the other person, because it incentivizes you to find a better solution.
Balwant sir. Sujit wants to say, contribute on this, yeah.
Yeah, I think we spoke about IP, and so I thought I just remembered something on top of my mind. I think it's a very weird question to ask in a law school, but how many of you are aspiring lawyers here? Not all. Aspiring lawyers. But yeah. Ravi spoke about others. Yeah, I just asked the question to check how many others. Ravi spoke about AI, and Dr. Sachin spoke about a business model of when you click on an ad, when a person clicks on an ad, some money gets transferred, etc. So it just struck me that we've been talking about AI and business models being enabled by AI. How many of you feel that AI will be a threat to jobs, or in particular, let's say, law profession itself? Like, how many of you feel there's a threat? Some like others around 20-30%. How many of you feel it's an opportunity? There is an opportunity, a bigger number. Okay, that's wonderful to know. So that's what I thought I'll just quickly develop on. Like, what are the opportunities that you might find when it comes to AI, and let's say business models when it comes to AI? What opportunities could be there? Even though if you're not a technology person, if it's still possible, is it there, that what I feel is, one is that productivity wise, of course, AI can supercharge a person. Like, any of you using ChatGPT currently?
How many writing papers using ChatGPT?
That is the important
That's the right
aspect.
question. How many of you have submitted term papers using ChatGPT?
Now that one.
and contributing to that, for people, as with the passage of time, you will be progressing to higher levels of education. So you see how AI actually can be a barrier to itself. You are using devices, softwares like ChatGPT to write a research paper based on a topic, and then when you have assessment, the people who are doing in the assessment, they will use another AI based software, okay, to tell you that your paper cannot be accepted because you have used material from ChatGPT. So do not think that, okay, there are smarter people all around.
And actually this has happened in one of the universities in the US, where
Correct.
the professor has given the question papers to people and also the answers which have been written by ChatGPT, to say that
Right.
in case now you submit, then I know that in terms of it's ChatGPT and not you. So you have to write something which the ChatGPT will not write.
And just to add to that before we come to next question, there has been a recent case in US in a court of law actually, which has stirred a lot of discussion. There is a lawyer, he was fighting a case, okay, it's a litigation based case. He made arguments before the court and he produced judgments of cases, which was later revealed after scrutiny that those judgments never happened in the universe. Okay, the AI based model made it up and even got them case numbers, hallucination part, and so the court finally ordered the lawyer that it's time that you get cancelled of your license, and then you have enough time to hallucinate in your home. So do not try to take things from ChatGPT or any AI based software without knowing what I was telling in the beginning, that as a lawyer you have to understand what is credible legal information. This is very important for you to understand. Any information picked up from any website may not be acceptable, credible information. So you have to understand, and you should give your client only credible information. Okay? So try and read books. Okay, books are meant for a reason. When you quote a textbook, you will not be challenged. If you quoting a AI based website, you will be challenged. That's the situation as of now. Okay, so be careful. Okay, so I'll move on to the next.
Just to summarize there, just be intelligent enough to use artificial intelligence intelligently.
Yeah.
Not use it, yeah. So,
Use ChatGPT, but it is your paper, so you have to read it and ensure that it is the information
Right.
in it is correct.
Not exactly related, but I think what Indranil was saying, just wanted to add one more point also, that what we do nowadays, and what Ravi you were also saying, is that mostly we get fed with data by the internet now. So for example, if you say that what is the best law school to go to, it will give you results, right? What is the best food to have, it will give you results. But some of them are biased towards a section, and it is driving your thought process towards what you are reading. So for example, if I say that is sunflower oil good for health, now Google can give you 5 responses. I'm sorry taking the name here, but any search engine can suggest you 5 links which will talk about sunflower oil is good, and any 5 links which will say sunflower oil is bad for health. Now, depending on what the search engine is feeding you, that's where our opinion is forming about a particular thing. And we at this point of time, where there is actually a lot of paucity of time and we don't have patience to actually dig deep, which Indranil was talking about, we would read the first 2 links which will come on the search engine page, and we form our opinion based on that, and then we start talking to people about it. That can be really dangerous.
Okay.
So that is one thing that you should all keep in mind.
Okay.
Yeah, again, I think I'll touch on a slightly different topic, again taking from what Sujit mentioned about business models itself, right? At least the way I have seen, in my experience, corporates change, or at least how IP as a function has changed in the recent years, is that the expectation from the business is that you are really a business partner and not just another corporate department. And believe me, and I'm sure at least there is Sachin and Ravi, both from organizations where they are the they are the CXOs, and I'm sure that they will also tell you that as a lawyer in the legal profession, they expect you to be business partners. Yeah, they expect you to come up with solutions and not always, oh, this is a problem, we can't do this. So even while you are developing into the professionals and whatever you are learning, also try to think about it from that perspective. And then if there is an AI tool which helps you analyze and give you good information, then definitely go ahead and use it. But keep in mind that at the end of the day, if you as an individual do not add value to the business as lawyers, I don't think the business itself can progress much far.
Just one point, I just want to kind of like bring out exactly like what I was saying. I don't know how many of you have, again, you're young, so you may not know. There was around 99, 2000 time frame, there was a big company called Napster, okay, that became extremely popular in US, mostly because they were sharing, actually the company was promoting basically MP3 based music, and it was becoming a freeware, right? The songs, copyrighted songs, everything that was kind of like going around and doing. The most intelligent business model that actually turned around that whole concept was done by Mr. Steve Jobs. He actually took the same concept and brought in iTunes, right? And you kind of like see that whole concept that evolved, and there are things that you can kind of like talk about a little further. So just to kind of like add the point, coming up with new business models, again, I mean, they are IPs by themselves, add tremendous value to the organization.
So, now that you talked about Napster and iTunes, the same thing happened with, let's say 10 years ago, we were all doing, what is it? Torrenting of movies, right?
Torrent, yes.
Today, we don't worry too much about paying for Amazon Prime or Netflix for the same thing, because it's also the pricing model which has come up. And it's also the model that bandwidths have become so cheap, that you can now stream. Earlier on it was so expensive, so you wanted to download it and then watch it on leisure. So I think one of the important things is that IP may also have a thing that the way people use IP or intellectual property, or people do pirating or whatever, also changes, I think, with the times and circumstances. And Lawrence Lessig has written a very good book on copyright law, where he basically talks about against the evergreening concept and thing. So a very liberal sort of an idea that copyrights are bad, and I think it's called Copy Fights. No, Copy Fights is another book. I forget what Lawrence Lessig's book is. So it's an interesting philosophical idea also about, we are here talking about protecting intellectual property, but then Sumanthan was talking about open source compliance and things like that, which is an interesting area also.
Okay, one perspective I would want to add on the innovation side, because that also the topic is, we are talking about IP, and in the era of AI, we all know that how AI is going to help in the IP side, IP generation. So in the morning session also we got clarity about IP, what IP is, and ideas and all that. But do you know that every year more than 2 million patents are actually filed, right? And so many ideas are actually getting generated. But as a lawyer, you have to think about what is the chance that that particular IP will come into litigation, or what is the portion of the IP, any idea, any percentage that you can say that what percentage of the actual IP that is filed actually gets to the market? Rough numbers?
Means sir is asking you a rough percentage of what is known as technology transfer and commercialization.
So actually you file patent for this, you think
Right.
something is there, but how many of them actually successfully are launched in the market itself? Okay, one guess is 10%. Anybody has a different figure in mind? 5%? Okay. So even if we take 5%, though actual number would be less than 1%.
Yes, yes.
What really happens, right? So 99% of the IP that is getting filed, and also a lot of effort, a lot of money gets also spent in there, right? What really is happening? So that is important part, because there is a difference between IP and innovation. And it's a journey, and I think some of the entrepreneurs are also there in the panel. They will also see that not all ideas, not all problems are actually successful in the marketplace. What really matters, because there is a lot of competition, and then there are a lot of different factors. So if you spot a problem, so first of all, spotting the right problem is also a challenge, because everybody would be looking at some challenges, but not all problems are worth enough. And even if you have an idea and you file patent applications, whether business-wise it will be able to get the attention. So in innovation, there's a very simple way to measure. That's also the rule that we also use in design thinking. You can think like a Venn diagram of 3 circles intersecting each other. So one circle is called desirability, second is called feasibility, and third part is the viability. So what does desirability mean? That is the problem really desired by our, the solving of the problem is actually desired by our customers or not? Is there a real demand for that? So if that qualifies the desirability part, then yes, problem is real. Then feasibility, that can you actually solve the problem through the technology that will serve the purpose, because there could be different approaches, but not everything is there. And then feasibility is done, but viability is that can you make a business out of it? That if you are in a loss making that, it may not really serve the purpose. So if you see, the task of coming from invention to innovation is a really big and very hard part. So if you understand this aspect, the evolution part, you can also try to see in what areas you can use that. And these principles of innovation is not limited to technology itself, right? In the law professions also, you can say, how can I be more innovative? Some of you would want to become an entrepreneur yourself, right? So for that also, the same similar principle will apply, that you are able to spot the right problem, you are able to come up with a solution, technology, non-technology, business-wise, all these, and then making a business case out of it so that you are successful as a business person. So in that aspect, now coming to the AI part, earlier it's a hard process, the manual way of really looking at hit and trial or experience, everything is there. But now technology has made it easy, where AI, through the data crunching and lot of information that is actually being circulated, you are able to get the right guidance through AI and Gen AI techniques, so that competitive intelligence, due diligence, technology trend identifications, where the right opportunity could be, lot of things can be really processed by the AI in that part. So if you know AI, how to use AI, so you can improve that percentage, you said 5%, to maybe more than 10 to 15% as well, which is still a big number if you know how to make use of it.
And maybe since you mentioned the legal part and technology, I don't know if the students have access to LexisNexis.
Yes.
So LexisNexis is one of the resources that you would use to do a lot of legal research.
LexisNexis manupatra hai.
I mean, if you've used it at least in some manner, you know that when you're trying to do a search query, again, it is like a search engine, right? It is going to give you some results back, and maybe on the right hand side somewhere it would say, oh, maybe this word, but were you looking for another word? Maybe it is when you said litigation, but what are you expecting alternate dispute resolution? And all these are enabled by technology. So even in the legal field, there is now, a lot of the technology and a lot of AI being used to give you better results. So this is only an example of one thing actually which you could use, more often to understand how this is playing.
Okay. So we go to next question.
On the same topic of how AI can help innovation, morning session we had the drug discovery things, and recently there was a news item. There's this company called Inslico which found a disease. At now 2.5 years they were able to find candidates. So what really is happening is that there's a lot of data which is being, and I think AI is a misnomer here, let me be very frank on that. AI is a buzzword, basically a big thing which says, no, it's not really AI, it's hardcore number crunching, which happens. There are standard, we can call it AI for the sake of calling it AI, but then when you call it AI, then you will also, you are the Borg and we will all be assimilated, that sort of a thing is what we come to. But anyway, computing techniques, these are essentially because they are able to do a lot of searches in a short period of time is the real essence of this. And though my computer science friends may get offended, but essentially computer science is all about making pattern searches in a large space, and computer engineering is about doing it efficiently. That's what my thing is. So one people write the set of algorithms or the ways to do it, and other people write the software that does it. So both are important equally, but that's what it is. So and then recently, I think last year or this year, I went to the World IP Forum, where one company was showing, what was the name of the company, do you remember, which was showing that ideation tool? Access Scout.
Access Scout.
Access Scout, yeah. So there's this tool which you could actually do an ideation with it, figure out what you want to look at. It will look at near and dear things, tell you ideas, figure out patents. So that's a very good start, I think, for you to be able to say where we should be moving around, and that's all what you do. Yeah. So those are the interesting areas.
So we'll move on to the next question. You see, while we are having the discussions, actually we have already answered 5-6 very important questions on how AI is going to, renovate, or is it going to cause a backlog in your proliferation of the technology, or is it going to be a challenge in technology, whether technologies like AI is a challenge to your professional upliftment unless you do not know how to create that AI. I do not think so personally, being the moderator here. I think AI is not going to take away your job. People who do not know how to use AI tools will, actually. So it's better that you start learning. Nobody is asking you to learn hardcore computer engineer programming now to create an AI machine. But if a software is created using AI which can better work than a traditional software, you being the user of this software, if it is a software of your daily use, you should know how to use the AI enhanced version. Otherwise, a person who knows that will take away your job. Okay? So AI, I do not think is going to take away your job. It's pretty much the scenario when computers were launched, people thought computers are going to take away your job. Computers never took away your job. They created more jobs. And I think this should be the scenario for AI, but that time will only tell. Now, moving to a little bit deeper into an aspect, now that the panel members have been talking about and we have been discussing about inventions and innovations and protections, and how IP protection is very important for proliferation and upliftment of a company for its own business. Now we are going into a scenario, suppose you are an owner of a company or a startup, so you are now working on a very lead technology, say for example, okay, say fuel cells, where you are working on a very green technology, okay, and you are enhancing the quality of the fuel cell, and you are getting a lot of patents. So now your company, in a very simple sense, is building a patent portfolio. Okay, so patent portfolio is meaning how much of IP you have, how much of IP is there in patents, how much is there in trade secret, how many has been monetized, how many are not monetized, is there talks going on for licensing. All these together make up your patent portfolio. So if I am a tech-based company, I want to take over your company or join hands with your company, I would like to look into your patent portfolio definitely. And then once you have a patent portfolio, understandably, So like it's like having so many chairs. Then the second question comes, now I have chairs, now I have to segregate them, right? So I come into the domain of IP strategy. How to segregate whatever IP I have. So my question to Balwant sir here is, how can AI tools help in IP strategy formulation and better portfolio patent management, you think, according to you?
Sure. So for a company like us, being an automotive company, in car there are so many technologies that are coming up, right? And literally we get more than 5,000 inventions and 10,000 ideas that what more we can introduce in our car, right? But not all ideas are worth pursuing, because as I mentioned that the success rate of those ideas, those problems or getting success is very less. And we cannot really file 5,000, 10,000 patents every year, because every patent is going to cost a lot, right? So resources are limited even for a company like ours. So we have to take a call, being an in-house thing, of what portfolio we should really want to do that, and it should be very, very strategic, right? Then we are not the only automotive company in the world, right? There are hundreds and thousands of other companies also which are typically doing the same thing. So if everybody tries to provide everything, then there is no differentiation. So what is the thing where we can do our best? Because let's say in our luxury segment, we should really focus on what our customers really want. So from business perspective, from technology perspective, and also from differentiation perspective, we do a lot of research to select only those ideas which are strategic to us, that where we would want to make our presence, because business strategy should be there. Second part is that those ideas, if we convert it to patent, should be impactful patent, that those technologies are not easily bypassable by others. So that if I file a patent but others can easily bypass it, then what's the use of putting it that? So that's why the scope of the patents should be right, and we should protect it in such a way that we are protecting every aspect of it.
Right.
So that even the loopholes or bypass is not really do that. So these are some of the ways where we are trying to optimize, and AI, now we are looking at it, it's providing a very good way, because now through this, it is easier to track the competition. Where are they inventing? Where are the gaps where we can differentiate for the future? And when we file patents, it is not for today, it is for 10 years down the line. So we have to really see what are the problems that our future customers will face, and for which we need to have patent protection right now. So that's why the role of patent portfolio becomes important, and the strategy should follow that. It should lead us to fulfill our business strategy and business vision from that side. So IP strategy will see that which patents we should really maintain, which patent ideas we should really drop, in what geographies we should really file it. So now it is a more data oriented decision, because AI is enabling us to do that data crunching much easier and faster than before. So that way we can then invest in the right technology and make our R&D more focused and productive.
I had a question on this. So there's this concept of prior art and patents, that anything that is known is not patentable. One IP strategy could be to actually create open source prior art and reveal certain things so that your competitors cannot go out and patent something in that area. What are your people's thoughts, all the IP strategists, your thoughts on that strategy?
Means you are asking for a more defensive publication strategy to be enhanced.
How much do people really use that sort of a strategy? The small things which you think are, as you said, there are so many ideas. Some ideas are just, it's worth too much cost, so you simply just publish it open.
So, we spoke about patent filing and the cost with patent filing, which is what defines the portfolio management, and also about segregating ideas into different buckets so that you decide what you want to do with it.
Right.
And if you don't want to file, how do you have a defensive publication route? Some companies used to do it, like Yahoo, IBM used to just publish it in some online bulletins where they are not interested in those. But we were talking about cost. So in India, patent filing cost is very, very less when compared to other countries like US, Europe. So at least what we do in Samsung is we file in India. Just file in India because it will get published anyway as a patent application. So a small section where we feel that the ideas are okay, like what was saying, it doesn't have a very long-term business objective. We know it's not of great impact, but we still file it in India. Two advantages with that. One is that, of course, it gets published, it's a patent, granted in India, even better. Second one is inventors are also feeling happy because they get a patent to their name, employees.
So I have another, this is related to the policy idea. If you file in India, you are basically showing yourself to be an innovator in India, which means the government might have certain incentive to they get is that also a rationale behind that?
That is
because there's this whole idea, right? Innovation is happening. Because the patent portfolio and research paper publications goes on the entire innovation chain. When you measure innovation, patents are one of those reasons to it. So that's why I'm just wondering.
True, yeah. Also, yes, it does add, but such cases are very small. Okay. As a organization matures, those small patent filings will reduce over time. Innovation also matures to a point that you'll file fewer of those patents. You would want to focus more on the other ones. But yeah, defensive publication, I don't think many companies still do it now. I don't see
not too much. Not
followed. IBM used to have this technology disclosure bulletins, TDBs. And Yahoo used to publish it in IP.com. Different people used to publish it different places, paying money to IP.com to publish it. But now...
But if you even put it as an IEEE publication or an article like that, that's also considered.
Enough, right? Yes. That's also...
Anything that is published means publicly known.
Google possibly put up all the Hadoop, all the MapReduce and all of it largely because of I don't know, some of those reasons.
And we'll go to the next question. The next question is for Sumantra. So we are talking about the innovation industry, we are talking about technology transfer, making money, protection of our company, but IP also has a very important role to play in the service-based industry actually. So my question to you is, do you see any impact from an IP service industry perspective, say patents, due to AI?
Yeah, and I would, and first the answer is yes, and I think it is, I would want to contextualize that from your career perspective also, and I think that we have discussed a bit that anything and everything, starting from say a prior art search or even to a patent drafting, nowadays actually people are starting to use AI ML based solutions to see that how much of automation can be achieved. And what we are seeing is that over the years, the accuracy in terms of what data or what output the AI ML driven tool is able to give us is slowly and is kind of getting better. But as of now, is it in a situation where it can replace humans? The answer is very much no. As Indranil was saying earlier, that it is more of an enabler or an aid to us to say that, okay, at least if they are able to do 50 or 60% of the job that we would otherwise have manually done, that saves time, and then you can look at whatever output is coming out of the AI ML system and then fine tune that, check for the accuracy, the veracity of the data, and then you finalize it and share. And that's why you will see that I think recently also I think the US PTO published a lot of guidelines around if AI is drafting an invention disclosure form or a patent application, what can be constituted as, because as of now the law says that the humans can only file, natural person can file a patent application, right? Our system cannot do it. So there have been a lot of guidelines which are coming out. So the entire policies are getting attuned to it. Slowly the jurisprudence also will come along those lines. Of course there will be some controversial cases, some high courts taking a different view. All of that will happen, but slowly things will evolve. In a nutshell, the point that we are trying to drive here is that it is inevitable, it is going to come, and it is going to, beyond a point of time, seamlessly integrate with our lives, so that we will not even understand that it is there and it is happening, right? And I can give you a very simple example of what I saw in one of the cars, and I got quite impressed. But of course, there has to be some amount of AI and ML which has gone behind it. And of course, Balwant would know about it, I'm sure. But for example, it is summers. So if you set your blower at a higher number, so there is a lot of fan sound which will be there inside the car, right? And I got a call and I took it on the car Bluetooth. Okay, and I did not realize it. First of all, I had that conversation, and once I disconnected the call, I suddenly heard the blower again came back to the original noise. So what the AI or ML system, whatever was there inside the car, did was that because it understood that I was taking the call inside the car, it automatically reduced the blower to reduce the noise inside the car without me even understanding it, because it was so intuitive in nature that I did not even understand it. But it happened on its own. Right? So those kind of things, right? So you will not even realize that things are happening, but they will happen in the background.
Okay. So the next question is for Siddharth. So this is related to the Indian patent system actually, because till now we have not dealt in depth with how the regulatory aspect is coming into our inventions and protection of innovations. We have just been hovering on the surface as to what inventions and innovations are, how AI is enhancing them. Now once we are talking about protection of our invention, definitely then I am under the region of the Indian Patent Act as far as Indian jurisdiction is concerned. Now my question to you is, what are your suggestions and thought processes that is our Indian Patent Act as it is, as I am talking today, does it have a robust system to incorporate the AI based inventions within itself to support the patent system, or do we require a change in the kinds of parameters that we evaluate for patents? Like should there be some relaxation in section 3? Should some sections be relaxed? Should the criteria be less relaxed when it comes to AI based thing? What is your opinion on this?
So my opinion there is, I think the patent law was made at a time when the technology is evolving. So I really don't feel that there's a necessity to change the law. So if you're asking or with the expectation that should there be a sui generis specific AI Patents Act, I don't think that is necessary. I think what is necessary, however, is a good guideline of how these should be dealt with and how each section of whoever is deciding on whether a patent should be granted or not is trained well to understand the difference. Because what happens, and I can imagine Sujit or Balwant or any one of us agreeing to the fact that when today we receive the office actions from the patent office, the quality of these office actions as against anything that we receive from Europe is not as good.
Not as good.
Yeah. But of course, this is, I would not say everything is bad. There are some examiners who are very, very good. But most of it is, cut, copy, paste from a lot of things. So what I think is what we need is a better guideline and not a change in law.
Right.
So this is my short and sweet.
Okay. Anybody else who would like to contribute to that?
So, as you are saying, mentioning, what do you mean by AI related inventions?
So these could be inventions where we so for example, training of AI models. Yeah, these could, so you can file patent applications for training AI models, right? And for such kind of an invention, whoever is examining the patent application then needs to understand what this means as technology. So I am going as far as absolute core of even training AI models.
Is that permissible within my question? As patentable subject matter?
Of course. So we have gotten these granted, not in India. We have gotten these granted outside of India. It is only a matter of making the examiner understand what this means, and exactly if there's a technical advantage to it, and the way the way in terms of practice this is taken care is that when you are doing your patent specification, there you need to be a lot more elaborate about how do you implement it, what particular system are you talking about. So while this does not go in the claim, it still needs to go in the patent specification.
You can also go into, like, the point that is being talked about is like, you can do such an, where if I have to use like maybe like instead of using 10,000 images to actually train the stuff, I might just use only 1,000 images to actually capture whatever is required and then do the process. So you can actually patent in those kind of situations.
Because those, the one that you're talking about, right, the software per se cannot be invented, that is not to be actually taken in a literal sense. And there's more to it, and I think the patent offices as well as the court of law have taken cognizance to that.
Yeah, so because recently FSF has given out a patent India, and their contention is that India has started patenting software. So while the US has started to come down or something. That was one of the conjectures.
No, but there the example of, for example, for what you're saying is that software is patented. I mean, think about it. You know, when we are talking about any software, and I don't get into the AI part, but I get into any software. Any software that I put in my car today takes input, does processing, and then controls something. So to that end, there is always hardware involved in between. So it's all about the way you frame it, the way you phrase it, and I think that should get you through.
Okay. So you want to speak on this topic? Okay. So since we are running out of time, we'll have one last question, and this has something to do with the fear of AI. Actually, what I think personally, it's my personal opinion, this AI has become a buzzword because whatever machine is working on AI, according to the person, okay, who is standing in front of the machine, that machine is performing better than you. If you are performing better than that machine, I do not think you need to have any fear of AI. Now this fear of AI may have two angles. One is the insecurity aspect coming because of your technological incapability. The other aspect may be arising out of ethics issues. So how are these two issues so connected, and what could be done to leverage these issues of insecurity and ethics part, so that AI could become a more friendly tool rather than being a terror? So this is the last question from this.
So Indranil, I will just expand on this,
Yes,
because
sir.
from a perspective of the students here, right? 5 years from now, whether the education that you are receiving right now, whether that would be relevant, because that's the question that is coming in every university.
Yes.
Because what AI is capable of doing right now through ChatGPT, for example, imagine how it will lead to. And I was also reading some research papers. So what are the skills of tomorrow that you can learn, so that tomorrow once AI takes over, you are still relevant?
Yes, you're still relevant.
Right. So one thing, if you understand from the AI perspective, AI works on data. It does the data crunching, calculations, and now extracting trends from the data part really, really well. So analytical part on data, the past learning that it can draw out of this, what you can do on paper alone, that analytical ability, AI is able to do really well. So you cannot really compete, but you can actually take advantage of it. Then if it is doing most of your tasks, then what is it that you are good at, right? So in that part, from a lawyer perspective, I feel that you also are interfacing with your customers. So the human angle, where if you can develop a little empathy with your customers, so that you are able to understand, so those communication skills, and also you talked about the ethics part of it, because how you interpret it or how do you use it is also going to be a lot of responsibility part of itself. So this is a time then when you are looking at, don't just focus only on the theory part of it. I would say get the practical part and get to know the customers that we are serving, the humanity, the society that we are looking at. We have a big responsibility. So use AI as a tool, but then AI is making you more productive more efficient.
Definitely.
So that you have more time available. So use that time to develop skills on interfacing, having more empathetic listening and interpretation. And then later on, once you want to use it. So human skills are going to be even more important.
More important. Anybody who wants to deliberate more on that?
So another thing is that the AI or the computer will help you find one solution, but I think it is, as a lawyer, you have to find the tod for that, for a court of law. Find something different. So that is where the real skills will come in. The AI will find out something that 90% of people will do. It is the extra 10% that somebody will have to think, this can happen this way, or find some arcane law judgment or something. I mean, I consider that AI is essentially just a tool for every one of us. And people will always think about that AI can do an invention, but well, AI is not creative enough as of this time to really do an invention. It can help you narrow down an invention, and then you have to use your own inventive system.
Just a quick note maybe. I feel AI would be like a business opportunity for a lot of lawyers, because after all, the primary responsibility for a lawyer is to protect the interests of your client. So when you talk about AI, Balwant talked about a lot of data, which means a lot more parties involved in the process of, there is something that's happening at the training. We spoke about training of a model. Somebody would have designed the model, you would be taking that model, then trying to train with data that you got from somewhere else, multiple sources. OpenAI is getting into trouble for using the data from different places, including Twitter and news sources. So you'll have more parties involved, so it's like an opportunity. Second is that a lot of compliance related issues that would come in, more and more regulations. Although the patent and IP related laws may not change, but there will always be laws that will evolve for compliance. So I think that will also be an opportunity for lawyers. So
I think another angle is going to be the domain specific AI.
Yeah, domain
I think
specific
we are
AI.
moving fast. ChatGPT is huge, but I think now people are still thinking we need to really look at domain specific stuff and have good AI for a specific domain rather than.
So what Sujit said, more AI, more litigation, right? So it's heydays for you guys, right? That's one. From a fear factor point of view, I think general, of course, AI would be an opportunity. But have you guys ever watched this movie called I, Robot? Will Smith.
Asimov's 3 laws of robotics, right?
Huh?
Asimov's
3 laws of robotics are there. I've read the.
So have you heard this concept about AGI, Artificial General Intelligence?
You give it to sir, we'll continue for some time. Sir is from semiconductor industry, and generally whenever IPR talks happen, primarily I've seen either most of the times patent takes away the stage. Okay, and there is very little scope where I have seen where people discuss GI due to intervention of government. Now a lot of talk is happening about GI, but I have found very few IPR conferences and symposiums where people have dwelt into the semiconductor technology, okay, protection, especially the Design Layout Act. So we already have an act to that, and so sir, since it is a very high level technology based on robotics, because no human being has the capability to make a chip or a processor, be it VLSI or a microchip. So technologies in that domain were already very much, into a higher level technological domain than making any other mechanical instruments. So how do you think, since it was already very high level technology, most of it was AI itself, so how do you think enhancement of AI will, cater to your industry? Are we going to have even higher memory and higher efficiency microchips at lower cost, or are we going to have better microchips but at a higher cost? And what about repairing or the machines running on them? It's not
sufficient that I make a microchip. That microchip has to be supported by the system. So we need to have an overall enhancement of the system also. And with the, if we look at the Indian jurisdiction, the Semiconductor Layout Design Protection Act, do you think that Act at present is capable enough to handle such proliferation of, AI technology to be covered under that Act?
Okay, your point's well taken, Indranil. So one thing for many of you probably may not know, like Indranil said, there's a lot of automation that has actually happened already in the chip design perspective. But you know well that tomorrow whatever laptops that you guys use or like you probably use for your software to be uploaded on a particular cloud, which may be Amazon, which may be Google, any of these things. There are a lot of chips that are going into that as well. So the interesting thing that is happening at this point of time is, just to kind of like highlight, there is a lot of application already happening in terms of doing the accelerating the design flow. Today, if you take chip companies like Intel or TI or like Analog, many other companies that you talk about, all these companies spend a fair amount of time in terms of designing their devices. That could be anything between like easily it will go into 18 months to 24 months even today. One is obviously the complexity has increased, but people like Google actually have done the application of AI into their device that they have designed called TPU, which is, it's called tensor device that actually sits on the Google Cloud today. That's something you can't buy outside, but it's part of their server. So if you actually do certain things on AI, they all can be mapped onto that part of the cloud. So that is already happening. People, other what is called as electronic design automation companies, like they are called like Synopsys and Cadence and companies like that. Many of them are also operating, making the design flow quite a bit in terms of doing that stuff. Coming back to your question, as of today, I am not very sure whether the semiconductor, the layout, the patenting part and things like that, I think it will have to be enhanced for AI. As of today, I think it's really meant for, all the ones that are kind of like defined. The act itself is predominantly kind of moves around what is done as of, like manual largely or like the other parts, but it will have to change if you're not at least, purely from a just a patenting part, but I think the flow and many other aspects will come into the picture. One another thing which is, I think it will become very helpful in that domain is the identifying the infringements. That's actually an area which is, so if somebody is kind of like need to figure out that this particular chip has, certain part of the design is actually maybe like copied in some form in another device. Today, it is, it's largely, it involves a lot of other non-automated systems. There are a lot of other things that you apply to kind of like figure out. I think the infringement part and figuring that out will definitely develop because of AI.
So infringement thing, I just remember the trade secrets session that we had at WIPF where they said that there was a NAND flash memory issue between SanDisk and Toshiba, somebody took his stuff, so there was all this whole idea that somebody had stolen trade secrets and they gave, so that's an interesting one to look at.
Okay. So if there are no more questions from the moderator side, is there any issue on which the panelists in specific would like to point out or dwell for the students?
open it up. So the panel is now open for any kind of queries that you might have related to this discussion or even outside this discussion related to law, inventions, jobs, how to enhance your capabilities, being a lawyer from non-law, from non-technical background. The panel will, give you their best answers as per their knowledge and experience. Anyone? So there are no questions. Please, please. Take this mic. Take this mic. Give him this mic.
Sir, as we all know, in the field of IP, there are many places like design, trademark, patenting. So as a lawyer, in the future, which area would you suggest has a lot of scope for me to practice in, say, trademark, design, and which would give me an edge? Anyone on the panel, sir?
I will tell one domain that, in my opinion, will ever live will be copyright. Okay, so it's a domain that actually goes through. I don't know how much you heard about software and certain other aspects. There are things that have challenged copyright in something called, in an open source that he mentioned about, what is called as copyleft. And there are lots of things going on in that domain. But there is, copyright still has, there is a lot of legal challenges, I would say, in the copyright domain. So if you ask me to vote and advise you, I would say copyright.
So, I just remembered something.
You said.
Okay, so, yeah, I think I would agree with sir. But I also feel that each of these domain on its own is very complex, and there are very complicated cases in each of these domains, starting from copyright, starting from patents, and trade secrets, all of that. So I think if you would ask me that what you can do is you can actually study all to begin with, and then based on your passion, on what you like, then you can choose a specialization. But in terms of prospect, they are, in my view, all equal, because if you become the best in any of these, you are going to make a lot of money.
Yeah, I think what my thought there is litigation in general. Yeah, because out of all the people who are sitting here who may be patent agents or whatever the case may be, or even if we are lawyers having a law degree, being in-house, I am not going to be able to go and litigate myself, which means that I'm going to have to find a lawyer to litigate for me. And that is where even in terms of the evolution of what we have in terms of the court system in India, if you have seen the judgments from Pratibha Singh or any one of these are specific IP judgments at IP specific courts, and there's always going to be a requirement of more lawyers who are who understand the litigation scenario, and of course who are able to tie in the technology part. So litigation as a practice is going to be booming and most sought after, and if you can then tie in technology, then I think like Sumantra is mentioning, I think you would be really sought after.
Yeah, so I think one skill or one law degree is not going to really be sufficient from that side, because you have to understand the different perspectives. So you need to know the business part, you need to know a little bit of technology, maybe human psychology. So all these interdisciplinary things would be absolutely required. So don't get fixated on only one thing, that you will see, be open, experiment, and see that where you have this passion, and also where you see that a lot of demand is actually coming, where you can actually add value. So I think you will realize for yourself as you go deeper and experiment, because for everybody the path will be different. You cannot say that only one path is the most promising.
Would you like to contribute?
I just had an aside on what Ravi was saying about copyright law. So if you remember, there's this whole discussion that whether AI can be owner of a copyright, whether it can be an author. So I was just thinking that when I was doing my course at NLS, my topic of discussion was actually the aspect of moral rights which people don't talk about in copyright. So I was just thinking that was an interesting conundrum, that can an AI be an author and still continue to have moral rights? That's just a philosophical question for everyone here.
I just wanted to add, add something here. Now, and I was having a discussion with a panel member about this in some other symposium actually. So when this question, this is a very important question, a very valid question that comes up in like any IPR symposium based on AI. Can AI based machine be an inventor? Can that machine be an author? Can that machine be a dramatic, personality? So now the question is, when we are analyzing this, I am asking basically a legal question. Okay, this must be understood. Now when I am asking a legal question and there is an legislation from the parliament or the authority to that, I think we should go back and look into that. Say for patent, when I am asking, can this robot be an inventor? So first thing that I would like to know from the Patent Act is, what is the criteria of an inventor who can file a patent? If you look at that criteria, okay, the people or the entity that can file a patent is either a juristic entity or a living entity, or if a person is dead, the legal representative of that dead person. Now, they are either a juristic entity or a living person. Okay. Now these juristic people and living persons, they both are characterized by certain legal and regulatory aspects like Aadhaar card, PAN card, okay, ration card, juristic entity company. Everybody has a PAN card and everything. Does a robot have a PAN card? Can I give robot a Aadhaar card? Then in the first place, the robot does not even qualify as an entity to file a patent or an inventor. So how is this question coming up, that if there is a robot who is making a drawing, can that robot become the painter or the thing? Which access? So unless my country or any other country has a system of law which empowers such machines based on AI or any other technology to have a social security number like US or Indian, some recognition system which can be used as a tax. Aadhaar PAN. So I do not know exactly why this question is coming up.
UAE or Saudi Arabia gave citizenship to some woman robot or something.
Sophia.
Yeah, something was there, right? So she becomes an inventor there.
No. So copyright, I will just say it. So that Mickey Mouse cartoon, right? So Mickey Mouse is out of copyright because copyright has a term
60
like it's like 75 years lifetime
60,
plus 60 or 70 60 years from
After
the death of
lifetime.
thing.
That's what the Lasega
So if the AI is generating and we are giving the right copyright to that, then AI will never die, right?
Never die. It's a perpetual machine unless something happens, a battery breaks down or something.
Yeah, just to coming back to your question about as an IP professional. See, as an IP professional, there are probably, like what I see is two routes. Either you become an in-house legal counsel of sorts, or an IP counsel, or you would have your own practice. That's what we are all, like some of us are like in-house IP professionals. So if you are an in-house legal counsel, then you would be trying to see how you can keep yourself updated with respect to solving the business problems, understanding technology. That would become your priority. That would be, I'm sorry? Yeah. So that would be the one route. It's quite lucrative in nature because that's a lot of people are renowned as legal counsels. They're big names in the industry and other things. Another, if you're having a independent profession as a legal profession, becoming an independent legal professional as a whole, then you might want to specialize in one field of IP, whichever you feel you get a liking towards, and then go ahead. Of course, litigation is money, so that's where you.
What I was saying was that he did not expect so many answers for his question.
No, sir, the more the better.
So we are done with this panel, and if there are no more questions, so ma'am can take over.
First of all, thank you so much to all the panelists. And it is always said, when the heart is full, the lips are silent. Thank you for breaking down the whole complicated things into tiny parts so that it can invoke curiosity among our students. And that was really great from all of your part, and thank you so much for that. And it always makes a whole lot of effort from the professional side to come down to their level and talk from their perspective. And I believe a good discussion always increases dimensions of everyone who takes part. And thank you so much for this sumptuous panel discussion, since it started off after a sumptuous meal. Thank you so much for that. So it's now time to felicitate our speakers. So I request Dr. Saha, first of all, to felicitate, and I'll read out the names. Are you ready? Dr. Sachin Garg, thank you so much for being here with us despite your busy schedule. Mr. Balwant Rawat, thank you so much, sir, for enabling us to know the nuances from the automation industry. Mr. Sujit Subramanian, thank you so much for making the sessions live with the contemporary issues. Thank you so much. Mr. Siddharth, thank you so much, sir, for the painstaking efforts to reach out to our students. Mr. Sumantra Mukherjee, thank you so much, sir, for being with us and making things simple and easy for all of us. Mr. Ravishankar Ganeshan, thank you so much, sir, with your inimitable style and voice for making the discussion different. I believe it's my privilege to felicitate Dr. Saha from my own hands. May I call up? I believe no faculty is here. Yeah. Shall we have a group photo, please? Thank you so much. No, will we be joining again for that? Just a minute. Just परिवार वाले ज़्यादातर लोग उनके लिए it will be too much. So I have got. What if they are already reached here? Just Aditi, just parallel sessions. I think some many of the students are here.
Just a moment, we'll wait. Aditi,
We'll just wait down whether we have tea and discourse or whether we have tea and come back for.
just check. Please. Shall we settle down? The other panel has joined us. The sessions are always, as usual, successfully completed. Aditi, Adi, settle down, please. Yeah. May I invite Professor Avinash onto the stage to felicitate the speakers, the panelists for the panel 2. I invite Dr. Rajendra Kumar Sapru onto the stage. Thank you so much, sir, for the time and the energy and for having made it for the day for us. May I request Mr. Prakalpa Sharma to please come on to the stage. It's our privilege to felicitate you, sir. Thank you so much, sir, for having made it us for the day. I invite Mr. Rahul Dubey onto the stage. Thank you so much, sir. With profound gratitude, may I call upon Professor Dr. Pinaki Ghosh. Professor Pinaki Ghosh from NUJS, Kolkata. Okay, yes.